You may have an office handling not to mention, but when it most of it not is a minor correction. So Ali Imam Shah is for the other side.
Yes. Two events.
One is to carrying versus 2015.
Well, only one humble request. In 3718 of 2017, hearing was concluded. Matter was stand for CAV,
Yes.
but one interim order was not extended. So 5 days.
No, last order was there.
last order
extended
was
till
interim order
the
was
disposal?
10th August.
No, till the disposal, no order is there.
No.
Oh,
So, well, can it be kindly
Very-
extend it so that we won't face
tomorrow two events.
better.
How many? Very.
May I beg to mention or matter appropriate application, lordships.
Appropriate application means what is
Lordships,
this?
the matter has been disposed of, but the handicapped woman, his name is Chandravati Jatua. The real lordships is appointed me through legal aid. Now the person is lordships recovered, and her name is Chandra Jatua, alias Chandravati. That's right.
Another I'm speaking lordship and that to active now my team. Another last occasion you lordship there asking. Dolabana for any service of so and also special messenger for.
Yes.
Another time special messenger for or to our public and it appears on the before that but or my that's his mother I not to be notified to Donovan. Kindly adjust to each time my
Let it be called first matter. So no issue. Okay. Gautam Bayan.
Yes, no.
Gautam Bayan versus State of West Bengal. Against the conviction under section 323, 324. After considering the entire materials on record and after considering the judgments passed by both the learned court below, it appears to me that the conviction the operative portion is as follows. There are reasonable doubt in the case that the present petitioner's use of sharp-cutting weapon to inflict the assault upon PW4 and PW5. Considering the same, the prosecution has miserably failed to bring home the charge against the present petitioner under section 324 IPC beyond all reasonable doubts. In that score, the conviction of present petitioner under section 324 IPC is appears to be bad in law. The impugned order passed by the learned additional session judge affirming the order of learned additional chief judicial magistrate regarding the conviction of the present petitioner under section 324 IPC is hereby set aside. CRR is allowed in part the order of conviction and sentence against the present petitioners for the offence punishable under section 324 IPC is hereby set aside. Petitioner are directed to appear before the learned additional chief judicial magistrate Rampurhat, Birbhum, on or before 12th of day of October 2023 to serve out their sentences for the offence punishable under section 323 IPC. CRR allowed, connected can application. Disposed of, order of stay is also vacated.
Lordship, that is the 500 rupees or something is that.
Whatever may be in the 323. We have to deposit 500 rupees.
Only confusion first that was.
Yes, only
allowed.
323 is there.
Because they are the daily wages labor at tolerable exercise was going on due to that is in this type of.
However, the section 324 punishment has been set aside. 323 is there. 500 rupees each. ID simple imprisonment 1 month.
1 month. Then they will have to go into custody. That should.
No, they have to pay the fine. That,
Yes, yes, Lordship.
that is the order.
Yes, yes.
Order of magistrate is like that. Yes, next. Mousham De Sarkar. CRR 3694 of 2018. Consider the entire circumstances, the instant criminal division has got merit and it is liable to be allowed. CRR is allowed. The criminal proceeding being registered PS case number 146 of 2014, dated 7th of 11 November 2014 under section 498A/306 IPC against the present petitioner, pending before the landed judicial magistrate third court Srirampur Hubli is hereby quashed. Grant application disposed of. Any order of stay valid. Next.
Will this matter?
Yes.
But in this case, insurance company not have to paid the compensation amount. It doesn't have relevant for this document and they long to withdraw their fee. Not to be able to take the 25%. The instruction will not be kept the records. But the any part will not have found the relevant.
No issues. Okay, please take down. The matter appears at the instance of the insurance company. Stop. Learned advocate for the insurance company, that is the appellant, submits that the appellant has already deposited the entire awarded amount along with the interest before the learned tribunal in compliance of an execution petition. At this juncture, the pendency of the instant appeal became infructuous. Stop. So he prayed for necessary order. But the learned advocate perused the written instruction from the appellant company, considering the submission and the written instruction. The instant appeal, it is ordered that the instant appeal be and the same is dismissed as not placed. Dismissed as not placed. Stop. The appellant is at liberty to withdraw the statutory amount which was deposited by the appellant via OD challan number amounting to rupees 25,000 via OD challan number 1652 dated 23/9/2013 along with accrued interest if any. The written instruction be kept.
In this matter, I am appearing for the petitioner.
Yes.
Mr. Ranjit Chatterjee.
Yes.
My lord, Mr. Chatterjee is engaged in court number
No,
720.
it is appearing under the heading of to be mentioned.
Madam,
Because
at the instance of the petitioner, this matter has come up. At the, we had on 5th of September, at the time of rising, I had mentioned that let the matter appear under for.
My
hearing
lord,
on 13.
actually, they are mentioning
already
they are,
intimated.
no, they have intimated us afterwards, after
But
mentioning
they
the code.
intimated us that this
They,
matter is going to appear
every time they mention
It
the
is
code
not-
without.
I understand. The matter has to be disposed of under hearing, okay?
My lord,
So-
fix any date.
So when we did fix the date? 13th,
We had fixed it on 13th.
we have fixed on 13th.
Yes, man. But they came up,
Wait,
with
wait,
yes,
wait,
man.
wait, just.
They
13th,
never intimated us.
Let it be on 13, if my lord.
yes,
Please,
13th is the date.
Yes, my lord.
Very well.
At 2 p.m. my lord, just kindly fix the time, my lord. If my
2 p.m. is the date
yes, my lord.
when I shall take all the WPA matters.
Yes, my lord.
Okay,
If some precedence can be given and can be kept at 2 p.m. my lord.
witness statement. একটা হিয়ারিং চলছে না সেটা অন্য ডেট দিয়েছি সেটা 33 ব্যাপারে 10 matters করে দিচ্ছি ব্যাপারে 10 matters please take down the matter appear at the instance of the petitioner. Stop. Learned advocate for the respondent. Opposite party is also present. Stop. Considering the submissions of the learned advocate for the parties, the matter is fixed for hearing on 13th day of September 2023. Most preferably within 10 matters. First 10 matters. Okay.
Grateful, madam.
Lawsuit, I am for the applicant, is the change with lawsuit kindly adjourn for a week, Mr. Mrs. Das Mukherjee was appearing for the New Assurance Company, so lawsuit kindly adjourn.
Now, what is the application? Application, what application you have filed?
So can you adjourn for this week lawsuit?
Very well, very well, not this week.
7 lawsuit, I am for the applicant.
Yes.
For the insurance company.
What is the application?
Application also is a condonation of delay also. So 110 days listed also kindly condone the delay is the injury is a minor, father is the applied for compensation. Kindly condone the delay submission of Mr. Bhattacharjee. Is appearing for the insurance company and the owner did not contest.
Owner is respond number 2.
This one number 2. The ex parte order. So fixing the appeal
Yes. Decision application under section 166. Appellant is the injured. What is the compensation?
The compensation was kindly come to the award
2,94,000.
94,000 on by considering the notional income of 15,000 per annum.
Yes.
So my humble submission is should be more and others part of the non-pecuniary and pecuniary not has been awarded and lordship also not awarded the future prospect also. So after that, so lordship has been awarded.
What about the injury?
Yes, lordship kindly to page
80% injury,
80% injury is 26.
80% permanent disability,
Permanent disability. So can
amputation.
permanent yes, percentage of permanent disability is calculated It's one leg has been amputated, right leg, from thigh. At the time of incident, was 12-year-old. Can be considered judgment.
So the notional income was adopted 15,000 per annum.
Per annum.
So what is your submission to that? What is your submission?
My submission, the accident took place on the year of 2006.
Yes.
So according to the common practice, the civil suit is 3,000. Because of under the impression that we could have earned at least 3,000 per month after attainment of majority. So under this juncture, the amount has to be considered. The income has to be considered. In that is also a judgment of lordship apex.
He was aged about 12 years only.
12 years only on that occasion.
What is the view of apex court regarding minors' income?
Minors income view of the apex court is that the income has to be considered 30,000 per month. That also affirmed by other coordinate bench also.
30,000
Yes,
How?
2,500 per month, 30,000 per year.
per year.
So 2,000. To 2,500. Sorry, I'm sorry. Sorry. So 2,500 rupees per month. That has been considered by the all the bench lordship also, honorable bench also considered in such way. And lordship, here the notional income as it appears from the lordship, second schedule, it appears to note that even non-earning person is required to 15,000 notional income. Lordship note the note of the second schedule. So accordingly, the learned tribunal consider the 15,000 per month accordingly, per year accordingly. Against that lordship, my humble submission that has to be considered 30,000 per year.
Two things. Let him finish first, then I shall.
Yes.
There's the one judgment. There's the judgment of lordship Kajol versus Jagdish Chand. Here
Yes.
this case of Kajol lordship, here the one minor very tiny girl is lost his IQ. Accordingly, the Supreme Court assessed the compensation by considering the yearly monthly income of rupees 4,846. But lordship here he is not that's the observation. Lordship kindly come to the judgment of Kajol. Kindly turn to page 538, paragraph 25. Having held so, here clearly the view the basic amount taken in the determination of attendance of charges in very much lower than side. But lordship, this case I cannot place in such a way that that amount has to be considered. But the ratio is that if he could have earned after attainment of majority, under that ratio I am placing. But the Kajol here is lost his internally. He's behaved like a child, even if attaining her majority. His at age of 90, you will behave as a 2 years child. Under this conception, the Supreme Court has come to this conclusion. So I am not going to that ratio placing before your lordship. So only with that the monthly income has to be assessed if after the attainment of majority could have earned on that 3,000. It requires attainment may not be required to attainment to ensure he does not suffer from the bed source. The claimant has placed before us notification letters Haryana of the year 2010 wages for skilled labor 4,846 per month. We therefore assess the cost of one attendant 5,000. She will require to attendant work of 10,000 per month, which comes to rupees per month using the multiplier present. Coming in the so lordship this is Kajol, the girl is treated as a 100% disabled person.
Yes,
Then Loshi kindly, then Loshi paragraph 26, but in addition 100% physical disability. Paragraph 27 Loshi, on factor which must kept in while as in the like that present. One is that claim can be awarded only once. The claimant cannot be come back to the court for enhancement award at the later stage. Paying the sometimes extra has been placed. Therefore, the court or the tribunal assessing the company in case of 100% disability, especially where there are mentally disabled, also should take a liberal view on the matter on awarding compensation. While awarding the amount, we are not only taking the physical disability, but also mental disability and various other factors. The child will remain bedridden for life. With mental age will be there. The 9-month-old child, effectively, while body grows, she will remain a small baby. We are delayed the girl who will physically become a woman, but is mentally remain is a month of old child. They remain old woman, old child.
and this
The
is
guy-
separate case.
No, that's a separate case. But Lordship, but Lordship, my humble submission is that the paragraph 25 that the child, the big child, but also considering the Lordship, the daily wages. His daily wages is
Cost of attendance was considered
no, the monthly
on the
income was-
basis of the daily wages
yes,
of
but in the-
Haryana.
Yes, no, Haryana daily wages means that is the circular under the Minimum Wages Act. The either unskilled labor or skilled labor, the daily wages 4,80,484 is per month. But Lordship, that ratio I am placing. So in this case, in the accident with 2006, if Lordship is 80% disabled, his one leg has been amputated. So further he will not his entire life he will suffer from his income. The entire life he will suffer from his income.
That's why 80% permanent disability.
That was permanent disability 80%. So how the boy will perform the entire of the life? For the reason, I am placing this ratio. And
No,
Lordship,
in this case, there are mental disability
yes,
of-
that I am
and physical
submitting. That I am
disability.
sub-
Yes,
yes, there is
the
a
separate
20%.
issue is there.
Yes, that is 20%.
Yes,
For the reason, Lordship, I am not going to the ratio as decided, the amount as decided monthly
I
income.
understand. Yes,
For
yes.
that. So 3,000 has to be considered by considering the monthly income of the deceased. If he could have earned after attending, at least he could have earned. And Lordship, kindly come to the judgment under challenge, page 30. Considering the materials on record, last paragraph, the both oral and documentary facts and circumstances in the present case, the court finds the victim in case the only child of 12 years and he suffered 80% permanent disability, exhibit 3, with amputation. Considering the age of the multiplier 15 is applicable in this case, notional income 15,000 fixed for his income. In view of the said fact, the petitioner
Why multiplier is 15?
according to the age, Lordship,
What is the age?
12 years. To the tribunal also considered the Lordship, the second schedule.
15 to 20 years is 18.
18.
In
But
Sarla Verma.
Lanet tribunal considered 15.
So what would be the proper multiplication? Multiplier in this case?
It's 18, Lordship. It should be 18. And accordingly, the following schedule accordingly assess the compensation 15,000, 15, and
Yes.
according to second schedule, Lordship, up to 15 is a multiply 15. So Lanet tribunal consider the second schedule that has no use as on date.
Second schedule of 163A.
By second schedule 163, and also consider the monthly notional income of 15,000 is taken from the second schedule because it is the 12 years old. And is further entitled to 8,000 for medicine purchase to the petitioner. As such, total compensation comes to 180,000 plus 8,000 equal to 188,000. Relying upon the ruling cited in the 2012 1 TSC 1 Supreme Court page 2, court kept in mind that is suffering a trauma victim not being able to normal work for pain and suffering for amputation of loss of enjoyment life and grant compensation of 1,06,000. So total comes to rupees 2,94,000.
So under non-pecuniary damages, 1,06,000.
1,06,000 has been granted.
Yes. Under non-pecuniary head.
So Lordship, the interest for the life. So what will be the non-pecuniary, whatever Lordship will assess, I will go by that. I cannot supply the figure that will Lordship will consider. So whatever Lordship will think, Lordship will consider. My humble submission is that the future cost will not be considered. The non-pecuniary loss as considered by the learned tribunal is not sufficient. It has to be enhanced. And the income I have already submitted, it should be considered 3,000, accident took place 2006. But 3,000 Lordship will not consider because of earlier bench also decided 30,000 per year. So I will go by that, the other division bench judgment. And Lordship, the interest or not also granted is the default clause, filling with 6-7% interest per annum shall be payable if not paid within from the date of order.
Yes, anything?
And Lordship, I am referring just to one judgment, sir, passed by our Justice Vivaswanjan Day, Lordship, can be used the judgment. But on the Lordship also considered 60% disability, and Lordship Victor Lordship also granted Lordship 2 lakhs for non-pecuniary damage. And here Lordship is the case of amputation. It's more than that. It's important. And Lordship is the 12 years old. So the marriage prospect has to be considered. That is not considered by the learned tribunal.
Yes.
Lordship, that is
Yes, for the insurance company.
3 things, my lord. Huh? 3 things, my lord. It's true, my lord, that there was a case of amputation, my lord. Court has considered and granted income 1,500. Now, my lord, in 2020 to 20, Rajendra versus National Insurance Company reported in 2027 SEC 256, my lord. I don't have the copy, I am just reading out the portion. The Honorable Supreme Court says, in cases of young children of tender age, in view of certain amount, neither their income at the time of death, nor the future prospect of the future increase of their income, nor chances of advancement of their career are capable of proper determination on estimated basis. The reason is that at such an early age, the uncertainties in regard to their academic achievements in career and thereafter advancement in life are of so many that nothing can be assumed with reasonable certainty. Therefore, neither the income of the deceased child is capable of assessment on estimated basis, nor financial loss suffered by the parents is capable of mathematical computation. Now, other 2020. It is 2027 SEC 256. Now, the question is,
Yes.
The question is, under what financial position the family is coming from. That has to be ascertained, whether where he was studying. There are number of judgments of the Honorable Supreme Court which says that it has to be considered, because the family, a child which grows in a normal family or a higher middle class family, that has to be considered, on the basis of which the determination should be done. Now, nothing is there in this application on basis of which the court has considered 1,500. I should be candid, my lord, that in such situation, since there is an application of 80%, future life has to be go on, and it has to be increased, but not at the rate which Mr. Roy is submitting. My lord, kindly enhance that amount, but not at that amount, that 3,000 or 2,500. Let it be enhanced, but not at that time. Because
Yes,
initially, so I just probably missed 30,000 per month, but now that also not be. After 3,000 also should not be considered by the 1,500. It be 2,000. It can be enhanced and that can be disposed of.
I'm fully agreed with Mr. Bhattacharya.
Because
he said
he-
3,000. I have also not given 30,000, then 2,500. That was
Let
my
it be
submission.
enhanced to 2,000.
And lordship,
2,000
my
and let
humble
it be
submission
disposed.
is that, but I cannot go beyond the already been decided by the Justice Patnaik in another cases. After that, they have filed a review in support of Kajol, but the Justice Patnaik refused to allow the reviewed application by considering that the income should be considered as a minimum wages act. But we are constant that 30,000 is the final. So Mr. Bhattacharya also the main party on that issue.
So
And
in my
lordship-
matter, it was argued that minimum wages that was not been accepted by this court, my lord, and the court decided according to this own merit, my lord. In my cases, minimum wages was not accepted at all, my lord.
Yes, I'm with him. I with Mr.
Because
Bhattacharya.
the
Certainly
income cannot be determined with regard to that 1,500, 2,000 or 2,000. Since there is an amputation of 80%, I am saying, my lord, let it be enhanced, but not at.
And the judgment which referred before your lordship, there is the death case. So that is different issue. The argument can be advanced, or the judgment is placed. I can place the judgment in if the issue is the death case. But that judgment is not applicable in this case. But he is the minor, is still alive. Is how he inter life has to be considered. That is the question before your lordship. So that the judgment is referred by Mr. Applicability in this case.
So one thing, my lord, let me finish my first one. I have referred a judgment which was related to death case, no doubt, but the ratio was with regard to assessment of income. Here, Mr. I is submitting on the income, saying that he has suffered an accident and for which he has suffered loss, the income has to be. There, in that case, also, my lord, the Supreme Court has categorically stated that income in cases of minor child persons cannot be determined. That was the issue record. And thereafter, Supreme Court decided in accordance. So I am not on that way.
yes,
My lord, kindly do not dispose it off. I have no difficulty. Interest should be granted. There is no issue, but not at the rate of 2,500. But kindly, because at the present situation, what the child is, what he is doing, that has to be also seen. The accident took place in 2006. We are in 2023, my lord.
So lordship will determine the issue in 2023, where it is suffering from 2006. Kindly consider this aspect also. I'm thankful to Mr. Bhattacharya to raise that issue. I did not.
Here.
The judgment has referred 2020. I have also referred the judgment of also 2020. While lordship in the case of Kajol. So whether victim was treated as 100% or not, or other elements has been allowed by the Supreme Court. I am not on that. But lordship here also monthly has been determined. Lordship, I have placed that. And also consider that there is a age of lordship 9 months only. 12. Here the Kajal is only 9 months old child. But Lordship, the Supreme Court assessed the compensation by considering the monthly income. That ratio I have placed by considering the minimum wages act.
Okay, very good.
And Lordship, kindly see also that judgment, paragraph 15. The R.T. Hatanjati case also considered. All the case has been considered. The Lordship, kindly turn to page 535.
No, in the case of Kajal, the issue is separate.
Issue is
Completely
separate.
separate.
Yes,
No,
Lordship.
why you arguing, I cannot understand. The Kajal is that the person is a very.
9 months old.
Yes, 9-month-old child,
On that.
both physically and mentally disabled.
Absolutely.
So that's
On that,
why there are some
minimum wages
considerations.
that considered.
Yes.
I am not placing that the minimum wages that. I am placing the judgment what our High Court decided in the all cases, the minor case 30,000 per year.
But where is the judgment? You show me the judgment.
Lordship, the judgment is set by Mr. Singh also appeared. Mr. Singh appeared with set by judgment.
Mr. Singh ki witness that.
No, witness cannot be. He's the senior lawyer. And Lordship, kindly see the set by is judgment.
Show me the judgment.
Yes, Lordship, and the reference. FMA 3610 of 2016, Sec 25, and I and Mr. Singh also appeared. But the Lordship also decided the issue. Is the age of
the fact of that matter.
he is 80% disabled part. He is also 80%
Whether
disabled.
it is under 166,
166. This is 166.
the judgment place karo tahole.
And Lordship, the father has the income of 3,000 per month should be considered in the case of minor victim. It is my submission. Moreover, he submit that percentage of disablement should be considered to be the extent of loss of future earning. So, as a non-pecuniary damage are concerned, he leaves the matter to the discretion of the court. That I have also left the matter to the discretion of the court. In the light of his above, the submission, he praised that enhancement of the compensation. Mr. Singh, learned advocate for the respondent number insurance company, submit that as per the evidence on record and observation of the land tribunal, the disabled through 80%, but the same was curable, which could be taken into account. That is not curable, it's the amputation. Further, he draws the attention of the court that the fact, as per evidence, father of the victim, he has already received 40,000 from the owner of the offending vehicle. That is different issue. Here he is not receiving anything. Having heard the learned advocate for the respective parties, we found that claimant has precisely raised the following grounds. Firstly, the multiplier method has to be applied for compensation. That is also my submission. Secondly, income of the victim has been considered 3,000 per month here also. That is my submission. Thirdly, the percentage of dividend should be the extent the loss of future income. Fourthly, the learned tribunal urging not granting major sum of towards few non-pecuniary damages. Here, non-pecuniary damages 1,06,000 has been considered. Lastly, the claimant is entitled to future prospect 40% future prospect. After considering the calculation, Lordship also calculated in such way 2,500 rupees per month, 30,000 per year, 40% future prospect, annual loss of income such and such, and earning and also consider 80% of the disability, and multiplier also according and non-pecuniary expenses, and also medical and future medical expenses. The Lordship also awarded 1,40,000. Ultimately, the award passed by the learned tribunal 7,24,000. That is the same thing, same case, 80% disability. But that disability may be different. Disability is more than that because there is a case of amputation. The case of amputation. Our High Court decided this issue in such way. Against that, there is a review filed by placing the ratio of Kajal, but ultimately the review is rejected. But that issue is still alive. In the case that is all my submission. At this under with that conception, I have submitted before your Lordship. Lordship considered 2,500 per month, that decided by your High Court by rejecting the review application, and after that Lordship considered accordingly, which are Lordship is considering. But here also the medical and future expenses also considered 1,40,000. Mr. Singh also present before your Lordship.
In this case, there is no physical future medical expense.
No, Nothing has been considered. That has to be
No,
considered.
in this case, there are no future medical expenses. Amputation, in the case of amputation, there is no,
Yes, yes, that I am, but
There is no-
consider, but consider.
no. If there is a chance of some medical treatment,
To
then you
develop.
can, yes, to develop or otherwise, then
You
you can, then you
Because
can.
we
pay.
are,
But here in this case, the
but
amputation is
Lord,
there, so no medical.
presently, so what I am informed that it, because of the, if we already one leg is amputated, the treatment is still going on. Is not yet been fully cured, or that, but that portion is still is suffering some ulcer is there. So there is no evidence. But Lordship, under that score, so it can be considered some amount,
No,
but not can be
No,
considered
where is your certificate?
certificate page 26.
Is there anything to that effect?
No,
Is
that is
there
that is
anything?
only the certificate. And Lordship, kindly turn to the evidence.
Nothing is there, only amputation of
Only amputation is there. Page
From thigh.
19, only amputation.
80% permanent disability. Yes. What is the evidence?
Evidence Lordship, PW3 is the doctor witness.
Refer me the page.
Page 19. His right thigh was amputated due to traumatic. The traumatic that what is there. And this is several certificate states the otherwise signature is there. So Lordship, kindly see that the right thigh was amputated due to traumatic condition. So still he is in traumatic condition. So whatever Lordship will decide today, it is the last, because of I cannot come further. This is for if he some development or some for his injury, then I cannot come before your Lordship for further. So the entire life he will suffer with one leg. That is to be considered. That is to be considered.
That is why 80% disability.
That is also 80% disability.
How you want more?
No, I am nothing more, Lordship.
Then-
I
And
restrict
not at the
myself to
charity of the
80%.
insurance company.
This is not the question of the charity. I am with the evidence. So that observation is that due to traumatic condition, he is suffering 80%. I am with the 80%. I am only income that has been decided
Yes,
for the
yes,
coordinate basis.
you
That
are
is
good.
that is, and 40% loss of future prospect. That is the entitled interest. That is the entitled. And Lordship, my further humble submission is that you kindly award some amount apart from the non-pecuniary loss for further future medical treatment. If
No, if
required.
there is required any medical treatment, where is the?
Lordship, that I've already disclosed with that. There is no evidence that is there any physical major treatment or that evidence is not there.
No, if there is no amputation, there may have some medical requirement of treatment of like that.
Lordship, absolutely.
After
perfectly correct.
amputation, there
Lordship,
is.
perfectly correct.
Yes.
If is absolutely that there is no development, there's already been
Yes.
ended, and now the ulcer position already been cured. Then question doesn't answer. Already enter the life, you will suffer what is in present position. I am not on that, Lordship. My humble submission before the Lordship, the enter the life, you will suffer with the one leg. The one leg has been lost. Some amount is expecting. This is a 12 years old boy. He is not yet started his career.
At the time of accident, he was 12, not now.
I am 12. I am on 12. I am on 12.
Time has not stopped there.
I am on 12.
I shall place other documents in there.
That's all?
May I place the evidence, my lord? Something I have to place also.
Yes, evidence of, refer me the
Father.
page,
Page 10, my lord.
evidence of PW1.
Yes. Why I was saying that the position of the family has to be considered, in what way the child was being brought up. My lord, kindly sees the cross-examination portion.
Yes,
Dr. Samanto treated my said son, Dr. Samanto did not issue any disablement certificate in favor of my son. My said son did not used to read in the school.
Yes,
So kindly consider two things, my lord. Mr. Roy was arguing on the basis of the future medical expenses. He says, the father of the son says that one doctor used to treat him regularly, but said doctor did not issue anything. And the child who had incurred an accident at the age of 12 did not read in any school.
yes,
Now, my lord, I would again place that judgment of 2020 AIR SC 3144 and that is also 2027 SCC 256 at page 14, paragraph 14, my lord. The Honorable Supreme Court says that it cannot be asserted in the manner and fashion the income, my lord.
yes,
It is, they have given evidence that the child has suffered an accident and with a disablement of 80%. That was accepted by the court below. The company has also given compensation in that manner, my lord. Now, at present, have from that matter, they have preferred an appeal, and this is on the issue of now, my lord. The accident took place in 2006, and we are to 2023. Mr. I has said that about the future medical expenses for rest of his life. Mr. I should also please document that what the child is doing at present, whether he's still going to any school or whether he is in any employment. What is he presently doing? That has also been considered, my lord. And this is a beneficial legislation. Accident causes, insurance company takes care, but not in this manner that it has to be given in this manner and fashion. না শেষ হয়নি এখন দেখি
yes,
kindly also comes to page 7 of the affidavit in chief filed the father, Sushanto Rai Chaudhary, of the minor daughter, son. Kindly sees his occupation, the father's occupation. The father's occupation is business, my lord. Insurance company takes care of the accident, but he, as a father, he has also take responsibility. He cannot burden the entire responsibilities of his son on the shoulder of the insurance company.
yes,
But
anything?
there-
Yes, anything further?
there are division bench judgments. If my lord so desires, can fix another date. In 2008, our High Court, in senior circumstances, have recorded that in cases of minor, my lord, 1,500 is sufficient enough. If my lord so desires, I can revise those judgments also, because my lord has to consider the date and the time when the accident happened, and the court consider the income of that financial, that area, zone or area type, not at these present.
They will come on tomorrow. Along with the judgment.
Kindly, my lord, day after tomorrow, my lord. Thursday, my lord. So I have some personal difficulty, my lord.
Very, day after tomorrow.
Lordship, today Lordship will condone the delay and record the
Please take down. Reference can. Yes. 1 of 2017, old can 102224 of 2017. This is an application for condonation of delay. Heard the learned advocate, for the applicant. The can 1 of 2017 is hereby disposed of with the direction that the delay in preferring the instant appeal is hereby condoned. Stop. There are
Some cost may be imposed.
there are two respondents. Among them, the insurance company has already made appearance. Stop. The respondent number 2 is the owner of the vehicle who did not contest the matter before the learned tribunal, and the impugned award passed ex parte against the respondent number 2. Accordingly, the notice of appeal of the respondent number 2 need not be served. Stop. The matter is otherwise ready for hearing. Or the matter in part. Release the matter for further hearing on 14th.
before the filing put it to
14th. As a part of matter. On top.
Lordship, paperwork file give to the record.
The paperwork filed on behalf of the appellant be kept on the record.
Lordship.
Lord, I am on behalf of the claimant appellant. There is a can for condonation of delay and the affidavit of service
How many days delay?
160. One.
The application states 129 days. And
Yes, 129 days delay.
But the Lordship will condone the delay. No issues about that. This is a case under section 163 capital E. But what I find, you know, this is accident of 2007. There was, you know, the alleged permanent partial disability of 25%. But 163A, you know, the accident of 2007, we are in 2023. You know, even if I admit, you know, whatever they say, you know, the formula is there, not 163. No court records would not be required. But I give up my entire case, even if I do not argue, you know, they would not go beyond whatever there is in the sheet.
Yes.
So, you know, lower court record, you know, in my humble submission would not be required. But whatever is the awarded sum, but only on that basis, you know, they are coming up with your lordship. So if your lordship will fix it up any day, not let Mr. Banik come.
Yes.
Your lordship not fix it up any day if it can be disposed of. Otherwise, again, you know, calling for lower court records preparation of paper book and 163 a disability case, a 16-year-old matter. It would again, you know, go to the
uncertainty.
65,000 was added.
Lordship.
Pecuniary damages 15,000, non-pecuniary 50,000.
Lordship. But I have also gone through this ground of appeal. The memorandum, what they have given. Be that as it may, monthly income cannot go beyond 3,000.
Yes,
Permanent disability is confirmed what is there in the schedule. Where would they go? Non-pecuniary is also the maximum saving is done. It is made in the act itself. So your lordship will take it up any day. Today your lordship will not hear out the appeals because that Mr. Bonik come and fix it up whenever my lord pleases. Your lordship will dispose it up.
yes, yes, very well. Please take down. Affidavit of service filed on behalf of the appellant is taken on record. Mr. Singh appears on behalf of the respondent insurance company. Stop. Decision application. Can Can 1 of 2016, old can 2635 of 2016. This is an application for condonation of delay filed by the appellant. It appears from the report of the stamp reporter that there are 129 is 9 days delay in preparing the instant appeal. Considering the long pendency of the instant appeal, the application for condonation of delay is considered and allowed. The appeal be admitted. Stop. Respondent number 1, National Insurance Company, has already made appearance. Respondent number 2 is the owner of the vehicle who did not contest the matter before the learned tribunal, and the impugned award was passed ex parte. Impugned award was passed ex parte against him. Considering the same, the notice of appeal upon the respondent number 2 is not required to be served. Stop. Learned advocate for the insurance company submits that this is an application and this is an appeal against an award in a case filed under section 166E of MB Act. Stop. The matter can be disposed of by hearing on the basis of the impugned award itself. So the calling for the lower court record is not required. Stop. Learned advocate for the
Not required at this stage. I don't know.
at this stage. At this stage. The learned advocate for the appellant also considered to the argument. Considering the same, the matter be fixed for hearing on
Friday morning.
this Friday.
This Friday.
No, this Friday I'll be on Hupal. Only Sunday and Saturday. Friday we have to leave.
Monday, Tuesday, anytime my lord please.
Yes. 19th.
9.
Where can one discuss?
I'm obliged to your lordship.
Yes.
Grateful to you, my lord.
Claimants are the appellant before your lordship for enhancement, my lord. Claimants are come.
Yes.
On last occasion, my lord, I have submitted. The number of claimants are 4. My lord, wife, 2 sons, and mother of the victim. During pendency of the proceedings, my lord, mother of the victim expired, and her name has been deleted from the cost title of the member by this honorable court, my lord. And the age of the victim was 57 years, and he was an employee of, my lord, Plant and Equipment Divisional Huldia Dock Complex, and employer has come and deposed and proved the salary certificate, and also on behalf of victim, my lord, claimant, on behalf of claimant, victims, my lord, income tax return has been submitted. According to last income tax return, my lord, income was 5,28,716. And after deducting, my lord, the taxable income, the income will come around, my lord, 40,000, and that has been assessed by the tribunal below.
Yes.
My lord, yes, I am not disputing that. My lord, here, my lord, the number, since the number of claimant at the time of accident, number of claimants were 4. So as per Sarla Verma and Punai Setti, the deduction should be, my lord, 1/4. My lord, your lordships will find from, my lord, deposition of the PW1, my lord, page 17.
So you want deduction 1/4
Yes, my lord.
and
Future prospect will be 15%,
what is the age?
57 years. Her, my lord, appointment letter has been, my lord, produced and proved by the employer concern also.
Yes.
And he was in permanent, he had permanent job at the time of, my lord. Thereafter, my lord, multiple will be 9. My lord, kindly see page 27. Kindly see page 27 of the paper book, how calculation has been made, my lord.
Now what multiplier was adopted?
My lord, 8 allotted but divided by 2 parts. One part, my lord, assess as per income 40,000 per month.
Okay, I understand. After 60, they are
My lord, yes. But your lordships have remembered the situation, my lord. I have, and my lord, 9,500 has been awarded towards conventional head. My submission is that will be, my lord, 70,000 plus, my lord, 10% increased as per Punai Setti. My lord, I have refer one decision, my lord, Kirti, regarding, my lord, deduction.
Yes.
Kirti, my lord, kindly see paragraph 10. Deduction for personal expenses analysis, my lord, we have thoughtfully considered the rival submissions. It cannot be disputed that at the time of death, there in fact were 4 dependents of the deceased and not 3. The subsequent death of the deceased dependent mother ought not to be a reason for deduction of motor accident compensation claims and legal liabilities crystallized at the time of the accident itself, and changes post there to not to
You are reading paragraph
10
10 of Kirti.
of Kirti. Kindly see paragraph 10 and 11, my lord.
11.
Paragraph 10, 11, both.
Yes, read out.
We have thoughtfully considered the rival submissions. It cannot be disputed that at the time of death, there in fact were 4 dependents of the deceased and not 3. The subsequent date of the deceased dependent mother.
I could not find out where.
My lord, paragraph 10.
Okay.
Page, my lord, 150.
150.
Yes.
I understand.
Got it, my lord?
Yes,
Kindly peruse.
I
We have thoughtfully considered the rival submissions. It cannot be disputed that at the time of death, there in fact were 4 dependents of the deceased and not 3. The subsequent death of the deceased dependent mother ought not to be a reason for reduction of motor accident compensation claims and not legal liabilities crystallize at the time of the accident itself, and changes post thereto ought not to ordinarily affect pending proceedings. Just like how appellant claimants cannot rely upon subsequent increases in minimum wages, the respondent insurer too cannot seek benefit of the subsequent death of a dependent during pendency of legal proceedings. Similarly, any concessions in law made in this regard by either counsel would not bind the parties, as it is legally settled that advocates cannot throw away legal right or enter into arrangements contrary to law.
Okay,
My lord, any compensation awarded by a court ought to be just, reasonable, and consequently most undoubtedly be guided by principles of fairness, equity, and good conscience. My lord, this has been ultimately 1/4 has been allowed.
very well.
This is one. Another is, my lord, regarding your lordship knows, my lord, the Sarla Verma and Punai Sethi decided the issue that 56 to 60, the multiplier will be 9.
Yes,
And my lord, kindly see this, my lord, here. In this case also, এটা হচ্ছে আমরা rest service period.
নামটা আছে না, নাম
দিচ্ছি দিচ্ছি দিচ্ছি। ওটা
R Valley versus Tamil Nadu
Yes,
State.
yes, my lord. Kindly see in this case.
No, you are submitting this judgment for,
For my lord, rest service period, my lord, left service period has been taken into consideration by the landed tribunal. My lord, 3 has been adopted.
no, according to the Sarala Verma and Punai Sethi, your submission, it would be 9.
9.
Okay, okay.
It will be 9. And my lord, here, my lord, paragraph 11, kindly see for a moment. Page 267.
Yes,
My lord, kindly see. Thus, we find that the method to determination of compensation applying true multiplier is clearly erroneous and run counter to the judgment of this
yes.
in Punai Sethi, affirming the judgment of Sarla Verma. Since the deceased was 54 years age on the date of incident, therefore the suitable multiplier will be 11. Here, my lord, date of accident on the
Would be
date of,
9.
yes, yes,
Anything?
yes. My lord. In regarding income, my lord, income tax return has to be taken into consideration.
It was admitted, it was
My lord, that
taken
is admitted.
40%.
My lord, thereafter, my lord, Rosmita Biswal, my lord, 10% hike. My lord, in Punai Sethi, 70,000 has been given on conventional head. Thereafter, 3 years has been passed away. So 10% will be added because in Punai Sethi, in that paragraph has been stated, and Rosmita Biswal is on that issue, and our High Court, my lord, also passed. I am asked. টেন পার্সেন্টটা তো আসবে সেটা 70,000 উপর 10%, 3 বছর পরে।
Refer me the paragraph.
Paragraph, my lord. My lord, paragraph 16. In Punai Sethi, this court has awarded a total sum of rupees 70,000 under conventional heads, namely loss of estate, loss of consortium, and funeral expenses. The said judgment of the Constitution bench was pronounced in the year 2017. Therefore, the claimants are entitled to 10% enhancement. 16,500, my lord, etc. has been given. Since, my lord, every 3 years, 10% will be increased. It has been, my lord, stated in Punai Sethi.
You
And
show me the Punai Sethi, not this.
And following this, my lord, our High Court also granting.
You show me the Punai Sethi.
Punai Sethi is not with me, my lord. I think your losses has seen. And 10% increment is going on. My lord, our High Court also granting that. My lord, kindly following that. My lord, page 5. Page 5, my lord, middle portion, my lord, further in view. My lord, starting from further in view of the decision in Punai Supra, the claimants are entitled to general damages under conventional health loss of estate, loss of constitutive relation to the tune of such and such, together with 10% escalation on the said heads, respectively. In each and every cases, my lord, our High Court is granting because my lord, Punai City said so. Punai City
Yes, anything?
Oh, my lord. And my lord, interest will be, my lord, as per your lordship. My lord, kindly see.
Read out.
My lord, reasonable figures on conventional heads, namely loss of estate, loss of consortium, and funeral expense should be 15,000, 40,000, and 15,000 respectively. The aforesaid amount should be enhanced at the rate of 10% in every 3 years.
In 3 years in pending cases?
Or my lord, 3 years from the date of judgment. In Rosmita Biswal, it has been stated, my lord, the judgment has been pronounced 2000 is yes, pending cases,
Where it
2017.
is written that the pending cases will be received?
My lord, it will be, my lord, in every cases. In every case, 10% will be increased, 10% will be increased every 3 years. Every 3 years. My lord, since my lord 2017, judgment has been pronounced. Now, my lord, 2023. Not 6 years has been elapsed because my lord, judgment has been pronounced in 2017. My lord, just October, 31st October.
Okay, give me the judgment.
Last. For that reason, Rosmita Biswal, my lord, stated so. My lord, last 62, before 62. 61, paragraph 61, last part. From which date the 3 years will be calculated, Rosmita Biswal has been clarified. That is from 2017 onwards.
Yes, anything?
Is that? And the claimants have received the impugned awarded sum.
You have received?
My lord, the impugned awarded sum of the tribunal bill which has been passed by the tribunal that has been received.
Yes, Mr. Singh.
Lordship, since the award has already been satisfied, Lord, I shall not be taking my lord to any of the facts. The money has been paid, money has been received. And Lord, for once, the points which have been taken to your Lordship, not all are correct. On the point of enhancement. Lord, the first point, Lord, I wouldn't be having any grounds to argue, but unnecessarily, Lord, I wouldn't be wasting your Lordship's time. Lord, first point, Lord, was on the point of multiplier. 57-year-old, Lord, Rana CTC is 9, following Sakam. The Honorable Tribunal Judge, Lord, has used the concept of a split multiplier.
Yes.
My lord perhaps has taken note of that. But the word is not used. Even the calculation what has been made, Lord, it shows it was a split multiplier because he was 57. The evidence is that he was about to retire on 16th. Yeah, 3 years left. So for 3 years, my lord, the multiplier of 3 was used. That would be the actual loss of income.
Yes.
But there was a judgment of Supreme Court, my lord, a larger bench judgment, Puttamma. Puttamma, my lord, in that case, this split multiplier theory was floated by Supreme Court.
Yes.
Supreme Court, my lord, said in that case that in appropriate cases, we will see to it whether this can be applied or not. But, my lord, good, bad, indifferent, my lord, whatever that is, Sarla Verma and then Prana Sethi, my lord, came up. And then those, my lord, said that no, for the residual years of service, leftover years of service, my lord, this theory of split multiplier you would
Yes,
not be
not
using.
applicable.
Rather, we would go by a straight jacket formula. So, my lord, today, before your lordship, my lord, I would not be again starting the issue of this split multiplier because, my lord, it may be a very interesting issue, but ultimately it would not lead to
Yes,
anywhere
yes.
because of planetary. So, multiplier 9, my lord, considering the age is correct. But as far as monthly income, my lord, that is the admitted position that I, on the basis of 40,000 rupees per month, my lord, he was an employee in Haldia Dock. So, my lord, on the basis of 40,000 rupees per month income, I have already paid.
Yes.
Lord, my London Finance Lord is rightly not disputing that income per month income. So income remains static at 40,000 rupees. Not the calculation is to be made on 40,000. As far as the personal expenses are concerned, Millard, though Millard, certain submissions have been made before the court, which do not, Millard, I do not find them to be trustworthy. But the statements are there. There are no contradictions to that. 57-year-old man, Millard, he died his second son. He had his widow, 2 sons, and the mother were the claimants. The youngest one, Millard, he came up to the court, he was 27 years old, and he said that I and my elder we all were, Millard, dependent on the income of his father. Millard, improbable, but still that evidence is there.
Yes.
Mother in any event, Millard, would be entitled. The widow in any event would be entitled. So, Millard, I was on the issue of personal deduction. Had there been not any single line in my favor, I would have argued that, but it's not there. 4 dependents, they all say that we were fully dependent on the income of the deceased father. The second son gave the evidence, and we do not have our any individual income. So that deduction brings 1/4. London Tribunal Judge has made it 1/3. So 1/4 on the basis of Kirti. Supreme Court is very clear. Future prospect, since he was in Haldia Dock, permanent employee, less than 60 years of age, so 50% has to be granted. And this lastly, the Prana City is very clear. My lord has gone through that particular part, that 10% increase after 3 years. So that also this 70,000 general damages. This combined head would also become 77,000. So all he succeeds in this case on all 4 grounds. Your lordship will kindly record my formal objection to that, and your lordship will kindly dispose it on. May we just make the calculation and show it to your lordship.
Yes.
Best, your lordship.
Please take down.
तो बनाना भूल मत कर
The instant appeal has been preferred against the judgment and award dated 23rd day of May 2012 passed by the learned judge, Motor Accident Claim Tribunal, Purbo Medinipur, in MSC case number 328 of 2010. The brief fact of the case is that the present appellants, being the claimant, filed one application before the learned tribunal under section 166 of MB Act for getting compensation on the ground that their predecessor was died in a road traffic accident due to rash and negligent driving of the driver of the offending vehicle, duly insured under the policy of the insurance company. Stop. The matter was contested by the insurance company before the learned tribunal, and after hearing the parties, the learned tribunal has awarded a sum of rupees 10,89,500 in favor of the claimants. Stop. Being aggrieved by and dissatisfied with the impugned award, the present appeal has been preferred for enhancement. Stop. Learned advocate for the claimant appellant submits that the learned tribunal has not considered the facts and circumstances of this case and came to an erroneous finding. He submits that the learned tribunal has considered the personal deduction of 1/3 of each income, which is improper. The number of claimants in this case is 4. According to the observation of the Honorable Supreme Court in Pranayasati, supporting the following the observation of Honorable Supreme Court Sarala Bharma, the deduction on personal expenses should be 1/4. He also cited a decision of Honorable Supreme Court passed in Kirti and another versus Oriental Insurance Company Limited, and submits that the Honorable Appellate Court has analyzed and decided the matter finally to the effect that if the legal heirs of the deceased is more than 3, then the deduction on personal expenses would be 1/4. I have gone through the decision passed in Kirti, especially in paragraph 10 and 11. Stop. Learned advocate for the insurance company submits that the learned tribunal has not committed any error in passing the impugned judgment during the pendency of the appeal. The one of the mother of the deceased has expired, so in this case the deduction will be 1/3. Stop. Had the learned advocate perused the materials on record, also perused the judgment of Honorable Supreme Court passed in Kirti, it appears to me that the Honorable Supreme Court has cleared the confusion regarding the demise of any deceased, demise of any legal heirs during the pendency of the proceeding, and it appears that the number of claimants were 4 at the time of filing the instant claim application. Thus, in this case, the personal deduction would be 1/4. Stop. In this case, the claimant was an employee of Holdia Dock, so he is so the claimants are entitled to get the future prospects, that is 15% to his actual income. Stop. It further appears that the learned tribunal has adopted the multiplier 3 and 5. It appears that the learned tribunal has adopted split multiplier in this case, but according to the observation of our Supreme Court in Pranay, the multiplier of this case would be 9, considering the age of the victim to be 57 years at the time of accident. Stop. The learned advocate for the appellant also argued for general damages of 70,000, which was awarded by the Honorable Apex Court by virtue of the decision in Pranay. He also argued that in every the decision of Pranay, it has been specifically mentioned that in every 3 years, it would be the general damages would be enhanced at the rate of 10%. Stop. The said principle was also followed by the Honorable Supreme Court in R. Valley and others versus Tamil Nadu State Transport Corporation. Also followed judgment not Akadu, Rasmita Biswal and others versus Division Manager National Insurance Company. Stop. Considering the entire circumstances, it appears to me that the claimants are also entitled to get the 10% of general damages over rupees 70,000. Considering the entire circumstances, it appears to me that the impugned award passed by the learned tribunal is required to be modified. Stop. For the just and proper compensation of this case. The calculation is recasted as follows.
He has taken 8% interest. At least
No, this interest is calculated on the enhanced
So,
amount,
Milord,
not entire amount, not entire amount.
yes,
only
Milord, 11 lakhs, he has taken Milord 8% interest. Yeah, Lordship, Milord, without creating any precedence, your Lordship will kindly make it 5%.
No.
All
That
grounds
should
are
not be- that should
8%
not be.
taken.
Nowadays, my lord, bank interest has been enhanced.
Calculation. Total compensation comes to rupees 38 lakh 3,000. Stop. the claimants has already received an amount of rupees 10,89,500. So the balance amount comes to rupees 27,13,500. Stop. The insurance company is directed to pay the compensation, pay the balance compensation along with 6% interest per annum from the date of filing of the claim application. That is from
That is from
9th of November 2010. Within within 8 weeks from the date of passing of this order with the office of the Learned Registrar General High Court, Calcutta. Stop. On such deposit, the claimants are entitled to receive the same from the office of the Learned Registrar General High Court, Calcutta on usual terms and conditions. What is your claim?
30 lakhs. My lord, I shall have to
Yes,
deposit at Bholam Court,
subject
please.
to payment of the,
Yes,
subject to ascertainment of payment of requisite court fees.
yes. I shall have to pay, my lord, 8 lakhs.
Ascertainment of payment of requisite court fees. Stop.
My lord, LCR be sent down, my lord. LCR has come, my lord. Kindly directly.
FMA is disposed of. Connected CAN applications, if pending, are also disposed of. The LCR is sent down forthwith to the office of the.
Because, my lord,
Tribunal.
I shall have to pay, my lord, the
Certificate copy.
I'm obliged, your lordship.
Mr. Bonik is there.
My lord, I am on behalf of the appellant,
Yes.
Mr. S. Gopadas Mukherjee. So, my lord, there is we put the special manager's cost for LCR, but
Let me see the papers.
due to our latches, the respondent number 2 is the owner of the offending vehicle. We could not service the we could not serve the notice of appeal along with the order. So kindly grant 2 weeks adjournment for the service of the respondent number 2.
Very. Please take down. The respondent insurance company is represented by Ms. Das Mukherjee, learned advocate for the appellant, seeks accommodation for accommodation to serve upon the respondent within bracket owner. According to the matter is urgent today, list the matter. According to the matter is urgent today, list the matter on September 28th.
Obliged to you, my lord.
Lord, item 11, I'm for the respondent insurance company.
Mr. Rahman is there.
Mr. Rahman is there. Lord. This case, but an award of 80,000, 80
Yes.
was passed. Lord. Now he has come up Lord, for an answer. The matter is not that complicated. Had he been there, Lord, this could have been disposed of. But would it be my lord's pleasure, my lord, just to pass it over? If we can't,
Yes,
we
yes.
can dispose. Grateful to your lordship.
Pass it over. First call.
Lord, item 12, this is,
I'm on the
Paul is-
exponent claimant, my lord.
but Mrs. Paul is for the claimant, Lord, she has not come today, Lord, she will kindly make this only not today.
Not today.
I'm blessed, your lordship. Thirteen hours, the claimant responded as to equivalent to forming up with the appellant's lordship. So I don't know whether he will. Someone of me, what password I'm trying to.
Yes. First call.
Lord, Mr. Rahman is there, but he has missed his brief. He will only make it out today, item 11.
Item 11, not today.
My lord.
Very well. Mr. Rahman is there.
My lord.
Mr. Singh
Very short matter.
that very short matter is there, it can be disposed of.
Not even without his brief, it can be disposed of provided books. Anyways, you also will take it.
Yes. Very well, count over.
I think,
Yes, pass over.
my lord.
Yes, Mr. Rahman. Mr. Pahad is there?
My lord.
Well, there is a can lot out of 5 claimants. One is the on died.
One died,
On died.
all died.
On. Number 2. Appeal number 2 died. So I shall be praying before Lordship Lord to expunge on them and decides the appeal in favor of 4 of the 4 claimants.
What is the name of the appellant?
Diary Pathu something. Diary number Cookie Borma. Number 2.
Who is she?
She is the mother of the
She is the mother of the victim.
victim. You are mother of the deceased. Number 1, Noni Borma is the wife of the deceased.
Wife of the deceased, who is the mother of the
the
deceased, she is the son of the
Son of the
deceased,
deceased. 4 is the
and
daughter
the
of
4
the
is the
daughter of the deceased.
daughter of the deceased. 5 is the
5 is also daughter of the deceased.
one of the daughter of the deceased. Very well. This is can number 4.
Can number 4.
Okay. What is the matter about?
The matter is not, the claim was filed initially not claiming rupees 18,000 per month income. And claim was 1,60,000. But subsequently not it was amended. And claim the income was enhanced to 3,000 per month. Not in the knowledge that they accepted it. But they did not amend the claim amount. Claim amount remains 1,60,000. And London Judge while decided the appeal block, found that not there as the not able to come to page 14 of the paper book.
Yes.
In your page 3 of the award. It is 1, 2, 3, 4, 5, 7 paragraph. It appears from the application
Itself.
that after amendment that monthly income of the victim has been enhanced to 3,000, found to be 18,000. But corresponding amount of compensation has not been amended. That has kept 1,60,000. PW1 has also paid for the amount compensation to the event of 1,60,000 being the interest. In view of the kind observation of the Honorable Supreme Court as to the income of any of the able-bodied labor, this tribunal is of the opinion that paid for compensation to the extent of 1,60,000 is less than amount which they would entitle if it is computed as per the table mentioned in the Schedule 2 of the MA Act. That's why Lord did not calculate the amount, only just straight away allowed 1,64,500. 1,69,500. 1,60,000 plus 9,500. So my prayer would be not for losses, not income should be calculated.
This is 163A application.
163A. Well, income should be not taken by humble submission 3,000 per month. Age is 42 years. So not as per schedule, multiplier should be 15.
Multiplier
15.
Multiplier should be 15. 42 years.
42 years.
14.
But no, right?
Okay.
And 66.
Okay. 15.
15. And deduction 1/3. And 9,500 added, that is better.
Only this much.
Only this.
Mr. Pandey, I think nothing has to. Very good. Please take down. Can 4 of 2023. This is an application for expunging the name of appellant number 2. Stop. It is the submission of the learned advocate for the appellant that during the pendency of the appeal, the mother of the deceased, that is appellant number 2, Huki Burman, expired. So her name may be expunged from the memo of the cause title of the appeal. Had the learned advocate peruse the application, considering the submission of the learned advocate for the appellant, the CAN 4 of 2023 is considered and allowed. Stop. The name of appellant number 2 be hereby expunged from the cause title of the memo of the appeal. Stop. The department to do the necessary correction within a fortnight. Stop. FMA 766 of 2011. The instant appeal has been preferred against the judgment and award dated 15 December 2010, passed by the learned judge, Motor Accident Claim Tribunal, Malda, in MSC case number 85 of 2009 under section 163 of MV Act. Stop. Next, the brief fact of the case is that the present appellants, being the claimants, file one application under section 163A of MV Act before the learned tribunal for getting compensation on the ground that their predecessor was died in a road traffic accident due to rash and negligent driving of the driver of the offending vehicle, duly insured under the policy of the insurance company. Stop. A very short point is involved in the appeal. Stop. The claimant has preferred the application before the learned tribunal for getting compensation to the tune of rupees 1,60,000 only. Stop. The income of the deceased was initially stated in the claim application to be 1,800 per month, but subsequently the same was amended to the tune of rupees 3,000 per month. Stop. Learned tribunal is of view that the calculation of compensation under the schedule 2 of the 163A, schedule 2 of section 163A of MB Act is not possible because the claimants has only claimed rupees 1,60,000, though they are entitled to get the same. So he did not proceed to award the compensation on structure formula, but awarded a lump sum amount of rupees 1,60,000 and 9,500 towards the general damages. Total 1,69,500. Stop. Learned advocate for the appellant submits that in this case the structure formula, in this case the compensation may be awarded on the basis of structure formula under section 163A of India. Stop. The learned advocate for the insurance company, Mr. Pahari, submits that the learned tribunal has awarded compensation according to the prayer of the claimants. Stop. The amendment was made to the effect of income of the deceased during the pendency of the proceeding, but the claim amount was not enhanced. So the learned tribunal has nothing to consider the more enhanced amount, more compensation amount. Thus, there is no error in the impugned award itself. Or the learned advocate peruse the materials on record, also peruse the paper book, including the impugned award. It appears to me that this is an application under section 163 of MB Act, wherein the claimants claim an award of rupees 1,60,000. The learned tribunal has awarded the same amount without adopting the structure formula according to the schedule 2 of section 163A of MB Act. Stop. It appears to me that the learned tribunal has committed error for not following the structure formula. Stop. In a case of compensation under section 163A of MB Act, the learned tribunal must have to be awarded the just and proper compensation. In considering to consider the just and proper compensation of this case, the structure formula of section 163A of MB Act has to be followed. Thus, at this juncture, I think it necessary to modify the impugned award passed by the learned tribunal by adopting the structure formula according to the schedule 2 of section 163A of MB Act. For the purpose of just and proper compensation of this case, the monthly income of the deceased is calculated to be 3,000 per month. Per month, monthly 3,000. The yearly income comes to rupees 36,000. After 1/3 deduction towards the personal expenses, the yearly dependency comes to rupees 24,000. the deceased died at the age of 42 years. So according to the second schedule of section 163A of MV Act, the applicable multiplier would be 15. Stop. After adopting the multiplier in this case, the award comes to rupees 3,60,000. Stop. The claimants are also entitled to get the general damages to the tune of rupees 9,500. So after adding all head, the award comes to rupees 3,69,500. Stop. You have already received. The claimants have already received 1,69,000.
That's 500.
69,500. Last amount কত হলো? তার আগে 3,59,500. 3,59,500 minus 1,69,000. 69,000.
69,000 minus 150. It would 2 lakh my balance.
It will be appear 2 lakh.
Balance.
2 lakh. So the balance amount comes to rupees 2 lakhs. The insurance company is directed to pay the compensation. We pay the balance compensation amounting to rupees 2 lakh to the claimants along with 6% interest per annum from the date of filing of the claim application, that is from 15/5/2009. Within 8 weeks from the date of passing of this order, with the office of the Learned Registered General High Court, Calcutta. Stop. On such payment, the claimants are at liberty to receive the same according to the prevalent rules, subject to ascertainment of payment of requisite court fees. Have you paid the court fees?
Court fee is paid.
How many? 1,60,000.
1 lakh.
You
I shall
upon
check it up. I shall check.
Okay.
I'm not to pay the amount in equal shares to the court levels.
Okay. On such payment was High Court, Calcutta. Now on such payment. On such payment, the claimants are entitled to get the same in equal shares, subject to ascertainment of payment of requisite court.
Also applies to
FMA 766 of 2011, along with collected can applications, are disposed of. LCR will send down at once. Welcome.
My lord, I am praying for insurance, United India Insurance. My senior MP Chakraborty is engaging at.
Mr. Rahman is there,
I am praying for not.
not today. Very well. 18 huge, which for the insurance company? Are you there, Mr. Pahari?
In this matter, my lord, I could not prepare the paper. It's a very old matter. But at that time, my lord, the system was different. But there was my lord, the prevailing rules that in all the insurance matter, the insurance company will prepare the paper. So I did not obtain the certificate copies. But a copy of the order is also there, the common order, in all the old cases. Now the system has been changed, procedure has been changed. If a logical will hear out the matter without paper, very short matter, quantum only.
LCR is there. If LCR is
But
there,
it is still in FMD number.
okay.
So
FMD
LCR
number.
has not been called for.
দেখুন তো LCR আছে।
It is FMD number, LCR has not been called. Unless number is modified to the FMD number, LCR is not called for. Now, why the that has not been done till date?
Give me the paper.
Now, in the case delay control in the year 2012, still not it has been kept in the.
You are the appellant.
I am the appellant.
Then it is not the insurance company, is not the appellant. You
No,
are the
Lord,
appellant.
I am not saying so. Delay control in 2012. So, Lord, the department should not allot the number FMA number and call for the records.
You are the appellant, you have not taken any steps, I think.
But I have my application has been heard and delay control. The departments ought not to call for the records. Now, without records, people also will not hear out the matter.
LCR be brought through special messenger at the cost of the appellants. This is the order.
So, order
You have not put any cost.
to order date to 2012.
Yes, the date when your delay has been controlled.
That's not the mistake on my part.
Yes, 2012. May 2012, your delay has been condoled and you are
16th of May.
directed to file the special messenger cost. Appellants are directed to file requisite number of informal paper. You are directed, not the insurance company. So what can be done today? You prepare the paper book or otherwise you have to put a special messenger cost. What you want? Very old matter.
Special messenger cost is about 2000 in Jalpaiguri. Not less than 2000.
$163 application.
No, my lord, 166.
166.
But it was amended later.
Initially 163, thereafter 166.
He was not a salaried person. Income calculated on the basis of the salary. Except only thing not that he received a sum of 1 lakh towards personal accident claim from another insurance company. That amount has been deducted. And
6,73,440.
40 after deducting 1 lakh. Calculated 7 lakh something. 7 lakh, 7 lakh,
Yes, 7 lakhs something.
73,440. And deducted 1 lakh not he received as personal accident claim. But my submission was that shall be deducted.
But LCR is required to be done.
my lord, call for the LCR for the usual course.
But the order is there for the special messenger. How can I?
Then I shall be within a year, within this week.
Okay. Within a fortnight,
Okay, this week will
within this week. Very good. Please take down.
and to call for the records within blood to bring the records in 2 weeks or 3 weeks.
In pursuance to the order of the division bench of this court dated 16th of May 2012. The special messenger cost was not deposited by the appellant for bringing the LCR from the office of the learned tribunal. Accordingly, the appellant is directed to deposit the special messenger cost in the course of this week. After arrival of the LCR, the office shall examine the same and if found complete, shall serve a notice of arrival of LCR on the learned advocate for the appellants. Stop. On receiving such notice, the learned advocate for the appellant on record is directed to file requisite number of informal paper books incorporating all pleadings and proofs of the LCR on such submission of the paper books, the matter shall appear in the list. Parties are at liberty to mention. So much to lose. Yes, next call.
My lord, I am for the appellant. I am led by my senior, Mr. Prabal Mukherjee. He is busy in another court. Kindly please give us a passover.
Passover in the first half.
No, my lord, preferably in the second half.
Who is for the insurance company? To come on second half. Let me see. You are in the second half. Very. Pass it over. One matter is fixed for special fixed matter. After this matter. Next. Mr. Rahman is there. Not today. Very well, not today.
26. 27.
Yeah. But it is an appeal, which railway. My lord, Mr. Satra has been appointed by your lordship. Shukruto Satra has been appointed by your lordship.
So come on, second half.
Second.
Yes, come on, second half. I have to have the matter. Second half, two matters is there. Thereafter, your matter will take.
But that won't take long. Criminal division.
Criminal division matter, it would take some time, half an hour at least. Thereafter, your matter. Thereafter, this matter. Very well.
Very short matter, so that
It can be
because
disposed
of
of.
all the matter also was adjourned.
No, not adjourn. I will take
Passed
up
over.
the rest matter. If time permits, I will take up the matter.
33 months.
Yes.
Very short matter, 163A appeal is very.
No, one matter is specially fixed at 2 p.m.
Not like that.
After that, I will take up the matter. No issue.
Right.
If time permit, I will take up the matter.
My matter 36, 37.
I will take up all the matters if time permits today. Okay,
It was likely to be fixed today as Melody has pleased to
very well. Come on,
admit this thing that
2:30. Come on, 2:30.
it will be done today, but
Come on after 2:30. Thereafter.
Please, madam.
Yes.
But the other day, when I had begun my argument, well, I had placed, my lord, the writ of the power. If I may just, my lord, epitomize, my lord, what I had argued the other day, my lord, the writ of the power under 482 of CRPC. I had placed the order of the earlier quash petition, my lord, filed by them, which was disposed of by my lord Justice Bakchi, where there is a finding by Justice Bakchi that at this stage of process, there is no ground for interference, but on procedural unsustainability, my lord, the matter was remanded back. My argument before your lordship was, my lord, therefore the remand was a limited remand. So all points were not left open by Justice Bakchi.
Yes.
And subsequently, my lord, the expert report was obtained. And on the basis of the expert report, my lord, process was freshly issued by the learned magistrate. And against that, my lord, thereafter they filed this present quash petition, my lord, seeking quashing of the entire proceeding, where, my lord, the similar grounds, similar and identical grounds, my lord, which were agitated earlier, were re-agitated before your lordship. My lord, so therefore, my lord, if I will take your lordship, my lord, I will proceed further. Only, my lord, before proceeding further, I will show two portions, my lord, from two documents. One was the order of Justice Bakchi, one paragraph, and then the expert report, another paragraph. But if my lord's pleasure will be to come to page 43 once, my lord, of the main petition, my lord.
Yes.
My lord, sees third paragraph, Mr. Milan Mukherjee.
Yes.
My lord, sees, my lord, because my understanding of this order was, my lord, they assailed the proceeding on 3 counts: factual wrong, legal unsustainability, procedural untenability. Sees, my lord, Mr. Milan Mukherjee, learned senior counsel appearing for the petitioner, submitted that the learned magistrate had failed to consider the fact that the petitioners were not involved in the treatment of the victim. Pausing here for a moment, it was a factual issue which was argued before this honorable court. And the second limb of argument was, and in fact, she was being treated by senior consultants who had been conveniently left out from the array of the accused persons. So it was legal unsustainability. And the third limb of argument was, it was further argued that the learned magistrate failed to consider the ratio laid down by the apex court in Jacob Matthew versus State of Punjab and other, and without obtaining an opinion from a medical expert, proceeded to issue the summons. So it was procedural illegality. And sees thereafter, he accordingly prayed for quashing of the impugned proceedings.
Yes.
Then, on the other hand, I am skipping this. Thereafter, the consideration kindly says, I have considered the submission of the parties. It is straight law that court should deal with the complaints relating to medical negligence with care and caution, while it is the duty of the court to postulate an erring doctor, to prosecute an erring doctor, my apologies, my lord, whose act of culpable negligence is the caution of the death of the victim. The process of criminal law should not be used as an instrument of harassment of a professional in a bona fide exercise of his professional duties. In this regard, reference may be drawn. Then, my lord, the Jacob Matthew was quoted. Then, my lord, next page, if your lordship kindly come to, a perusal of the.
Yes.
A perusal of the summoning order in the instant case shows that there is complete deviation of the aforesaid procedure, in as much as the learned magistrate on the mere ipse dixit issued process against the petitioner doctor. Summoning of an accused is a serious matter. It puts a shadow of culpability upon the life, including the professional activities of an accused doctor. Under such circumstances, it was incumbent on the part of the learned magistrate to enter into a deeper analysis of the facts and circumstances in a case where the complaint was lodged alleging acts of medical negligence under section 304A of the Indian Penal Code. Moreover, the medical opinion relied on by the opposite party number 2 was not before the learned magistrate at the time of issuance of process. Hence, I am inclined to set aside the impugned process and remand the matter back for further inquiry under 202 of the Code of Criminal Procedure. However, in view of the natures of the allegation, I feel it would not be prudent to quash the criminal case as a whole at this stage.
Yes.
So therefore, the remand was a limited remand only on procedural unsustainability.
Yes.
Factual aspect was considered, argued, negative, Legal unsustainability was canvassed, again negative. It was, my lord, not an open remand, and from the rest of the judgment also, your lordship will see, it was nowhere mentioned that all points are left open, which is generally, my lord, done by the honorable judges. Then, my lord, I will place one more paragraph, my lord, rather one paragraph from, my lord, the expert's report, which was, my lord, which was obtained by the learned magistrate after this order. If I may request your lordship to come to page 52, my lord.
Yes.
My lord, kindly sees what are the documents before the board. Your lordship will see number 5 was opinion of medico-legal expert Professor Ajoy Gupta. It was before the learned magistrate also, definitely for the second time. When initially process was issued, my lord, there was no opinion before the learned magistrate. Then, my lord, kindly comes to page 53. Sees, my lord, considering the patient condition, the last paragraph, my lord, 1, 2, 3, 4. If your lordship sees the case of the complainant is unequivocal that there was no treatment, and that was upheld. Sees, my lord, 1, the patient has not been attended. My lord has seen at page 53.
Yes.
Has not been attended by the doctor of surgical ICU from 2 a.m. of 30th July 2014 to 9 a.m. same day, as there is no documentation of notes. Such serious patients should be attended frequently. 2, there is no documentation of notes informing patient's relative about the seriousness of patient's condition. 3, the treating consultants were not informed about the deterioration of patient's condition, as there is no documentation of note. 4, however, no definite evidence in absence of any doctor on duty of surgical ICU, as complained by the petitioner, was not found, as there are notes from 2 a.m. of such and such to such and such. It can only be confirmed if attendance is, my lord, will kindly, if I may request your lordship to note this, it can only be confirmed if attendance sheets and duty roster of the doctors of the particular day can be checked. Well, these documents, despite repeated summons by the learned magistrate, were not given by the hospital. I will show, my lord, from the documents. And thereafter, my lord, the opinion was given, wherein, which was, I mean, where the emphasis was given by Mr. Ganguly was at page 55, my lord, the last paragraph only. However, there are some technical lapses, your lordship has seen that, an improper documentation of the treatment procedure in the terminal stage, but whether it has led to or hastened the death process of the patient who was already suffering from malignancy disease in the terminal stage could not be ascertained. So it was the argument of the petitioner before your lordship that since the board could not find that whether this was the exact cause, my lord, then no summons should have been issued. My lord, my submission before your lordship would be, my lord, this is for a honorable, for a learned magistrate to decide. But the opinion of an expert at the end of the day, the way we have to analyze is a corroborative piece of evidence. My lord, under the scheme of CRPC for issuance of process in no offense, the opinion of an expert is required. It was in Jacob Matthew, my lord, in order to protect, my lord, the diligent doctors, my lord, the honest doctors, this was read into CRPC that if you file an FIR before anything proceeds further, then there has to be an expert's opinion. In case of a complaint also, before process is issued, an expert opinion will be required. Yes. But when the expert, the board, my lord, the board of experts, the board itself is in a dichotomy, my lord, it cannot be said, it will be no solace, my lord, for a complainant to say that, look, the board is not in ad item, the members of board, so therefore there will be no process issue. Because the purpose is to protect an honest doctor. But here the board, A, first admitted that the relevant point of time, after she was shifted to surgical ICU, there was nobody and she was not attended to. And this is a case of, my lord, no treatment. It's not of, my lord, wrong treatment. So that was affirmed. But what will be the ultimate result, my lord? That is for the honorable court to decide. My lord, that test I will place before your lordship, my lord, in Bolan was in order to protect, my lord, the honest doctors. That you have an opinion from the expert. But that was adopted by our Supreme Court, my lord, in Jacob Matthew. Now, subsequently, my lord, in UK, the situation arose when apparently the opinion given by the board was found to be suspicious. The doctors were shielding the doctors, my lord. Then it was decided that what is to be done. Then their lordship said, my lord, that no, then Bolan is not the proper test. Bolan test was diluted and said that no, in such a case, court can definitely look into the matter and issue process or prosecute the doctor. And court will not be bound by the final outcome of the opinion. But that was a subsequent judgment, but I will place all this of Bolitho, which was, my lord, applied, borrowed in our jurisprudence and applied in our jurisprudence by Honorable Supreme Court, my lord, by Justice S.B. Sinha, as his lordship then was. And this is a case, my lord, where the parameter, what the complaints I have from my complaint, my lord, I had placed, I will not trouble your lordship again with that. All were admitted by the board. But the board said, look, we are not in a definite conclusion. No, but that definiteness is not required for issuance of a process. But if a process is to be issued after being definitely satisfied of the guilt, then we deepest statement, what is the need of the trial? It's like, well, we are putting the cart before the horse.
What is the purpose of Jacob Matthews?
But Jacob Matthews' purpose is to see that, my lord, only on the ipse dixit of a litigant, he should not prosecute a doctor. That suppose, my lord, I was in a hospital, I went to a hospital, there was no treatment, or rather there was a proper treatment, which was, my lord, what Jacob Matthews said, that error of judgment, that medicine A was supposed to be administered to me, doctor opined for B. So there was an error of judgment. Now, only on that count, I cannot prosecute a doctor criminally. So just to give a check to that, my lord, I will demonstrate before your lordship from Jacob Matthews.
Yes.
Because otherwise, my lord, kindly appreciate, my lord, the reverse direction, in a reverse direction, we apply this, or if we extrapolate Jacob Matthews, the difficulty will be a court has to be definitely sure of the guilt of a person before the trial proceeds.
No. The issue is that before
Please,
issuing the process, prima facie, the magistrate has to satisfy.
Absolutely,
This
my
is the only
I'm obliged, your
The
lordship.
Jacob Matthews is there to prima facie satisfaction
I'm
of
obliged to
the
your lordship, my lord.
magistrate whether any offense has been committed or not.
Right, man. No matter whether, and the language your lordship has said, we cannot say definitely. So that definiteness, that accuracy is not required. Your lordship is absolutely right, my lord. So that's why the expert opinion is a corroborative piece of evidence. We should corroborate the allegation. Normally, here the allegation was of no treatment. So those are corroborated.
Yes.
Now, the ultimate conclusion to a definite extent, my lord, will be decided in trial. So therefore, my lord, my argument will be the expert opinion is corroborative in nature, and that corroborated the main allegations.
Yes.
And on the basis of such allegations, my lord, on the basis of such allegations and the expert's report, the process was rightly issued by the learned magistrate.
Yes.
And now, this being, my lord, a second quash petition on account of limited remand, my lord, other aspects barring this procedural aspect cannot be re-agitated by the petitioner, nor that can be considered by this honorable court. It's my respectful submission before your lordship, because this is, my lord, tersely saying, my lord, second bite of the chain for the complainant to, sorry, my lord, what the petitioners, my lord, they want. Second bite of the cherry. Now, my lord, when I had placed that expert's opinion, that particular paragraph I highlighted before your lordship, that those things, whether she was properly, I mean, so far ICU treatment was concerned, first of all, she was not attended, and further documents were also not provided to us, so we could not give our definite opinion. But I kindly comes to my affidavit in opposition. But this is the most bulky document because we have annexed all papers, my lord, of pertaining to this case from every forum, my lord, where we have filed cases, my lord. My lord, page 68, if I may request your lordship to come.
Yes.
But kindly sees this was an order prior to the process by the learned magistrate. Well, order dated 3rd of October 2016. My lord has got it, my lord. But if I may place this order, today is fixed for awaiting report from Superintendent, NRS Medical College and Hospital. Hajira is filed on behalf of the complainant. Learned advocate for the complainant is present. Learned advocate for the complainant expresses his client's anguish for not getting any fruitful result, but the delay in getting justice for the unexpected death of his wife at Apollo Gleneagles Hospital during treatment. Learned advocate for the complainant submits that as per the information, Apollo Gleneagles did not provide the requisite documents to the superintendent NRS Medical College, and as a result, the medical board has failed to perform and reach into any conclusion against the erring doctors in this case. And since, my lord, thereafter, my lord, it will be towards the bottom, your lordship will have on perusal of the documents filed, if I may please, by the complainant, Vide Firisti dated 7 September 2016. It also appears that the Doctor of Health Services Administration of West Bengal, Vide memo dated such and such, also requested, my lord, kindly sees, the medical director, Apollo Gleneagles Hospital, to provide copies of document, investigation report, OT records, etc. But the concerned hospital did not provide those documents to the Director of Health Services. Pausing here for a moment, my lord. This was argued by them that if hospital could not do, what can I do? What would the doctors do? But it's apparent on the face of the record the way the hospital was shielding the doctors, my lord. And sees thereafter the finding of the learned magistrate. In these circumstances, I am of the opinion that this is evident from the record and communications with the director Apollo Gleneagles Hospital that the concerned hospital is reluctant to provide the relevant medical documents to medical board, or it can be said that the concerned hospital is willingly trying to suppress those documents from medical board. In such circumstances, I hereby directed Superintendent of NRS Medical College and Hospital to be more strict and firm in calling those documents from Director of Apollo Gleneagles Hospital and provide specific report in this regard to this court with the next date so fixed for hearing. Now, my lord, no question for why, my lord, sorry.
Yes.
But no, the argument that if the hospital did not provide, what would the petitioners do is a faulty one, because my lord, it's apparent from the record that the hospital was shielding, my lord, and protecting the doctors, as the hospital was not a party, my lord, in the criminal prosecution.
Yes.
So therefore, my lord, it's the benefit will definitely go to the petitioners. That's why, my lord, these were not given. And on this score, my lord, the board subsequently in the final opinion held that all documents were not given to us. So definitely, my lord, the opinion will not be, my lord, I mean, definite.
Yes.
Now, my lord, your lordship has seen when the expert, they had given report, opinion, they had given opinion on the basis of the documents, which included, my lord, the opinion of Dr. Ajay Kumar Gupta, which was before the magistrate second time, not in the first at the first occasion, my lord. If I may place that opinion, my lord.
No, that's opinion with the report.
But of the Dr. Gupta, which was mentioned in the opinion.
Yes.
That
it is annexed with this petition.
But it was not annexed, but it was earlier handed up initially. I don't think your lordship will get that copy.
Now, whether they filed it or LCR is there like that.
LCR has not been called up. That has not been called for.
So it is the report.
Well, it was there only. But kindly comes to once in the petition. Kindly comes to this is nothing out of record. See page 52 once 0.5. It is that document only. My letter is in page 52.5.
Yes.
Opinion of medical.
That is annexure E.
Right, my lord. So which was before the court?
Before the board.
Before the board. No, my lord, it was before the board and before the court also. Because that was part of, my lord, annexure of the board's report, which was before the court, my lord. So invariably, this document was before the court, my lord.
Yes.
But this was a detailed opinion well, by a very, very reputed doctor. Well, first, initially, your lordship will have the case of the complainant, then the relevant part will be, my lord. The second page, last paragraph, my lord. Only the relevant paragraphs I'll be placing. From the brief summary of the case.
Yes.
From the brief summary of the case as mentioned by you, course of action in this case started when, cause of action, sorry, in this case started when on reaching the Apollo Gleneagles Hospital on 30th July 2014 at about 6:45 a.m., your client Madhav Chandra Mitter noted something abnormal in the clinical condition of his wife, Mrs. Sushmita Mitter, who was staying at surgical ICU of the said hospital, and the surgical ICU in charge, Dr. Siddhartha Soman Mukherjee, but the second petitioner before your lordship, who was supposed to remain in charge of the surgical ICU till 10 a.m. on 30th July 2014, was nowhere in sight as less than 12 hours earlier. The chemo poke, in fact, was removed on 29/7/2014 by Dr. Shubhankar Dev on the above advice of Dr. Such and such Mohapatra. On the very day, it was assured by Dr. Siddhartha Suman Mukherjee, the second petitioner before your lordship, the surgical ICU in charge at that point of time, that he will be in charge till 10 a.m. next day. That is 10 a.m. 10th July 2014. It is very much astonishing to note that the nurses informed Mr. Mitter that Dr. Siddhartha Suman Mukherjee had left, time not mentioned, and presently blood pressure of the patient was drastically falling. Mr. Mitter frantically asked the nurses to contact the consultant, who flatly refused, stating that consultants can be called only by the doctors on duty at the intensive care unit. As Dr. Siddhartha Suman Mukherjee was not available in the ICU at that material time, Mr. Mitter on his own managed to find another doctor patient in the adjoining ICU, and on repeated request, the said doctor, who later identified himself as Dr. Nilanjan Indu, but the first petitioner before your lordship, came to see the patient and advised the nurses verbally to direct administer adrenaline injection, but he did not write any prescription in the treatment record and left the surgical ICU. He directed Mr. Mitter to go out of the surgical ICU immediately, even as Mr. Mitter earnestly requested him to contact the concerned consultants. At about 9:15 a.m. on the same day, the nurses reported to Mr. Mitter that the patient had developed cardiac arrest, sudden stoppage of heart, and the nurses have started CPR. Finding no other alternative, Mr. Mitter again rushed into the adjoining ICU and again earnestly requested Dr. Indu to come and see the patient. Dr. Indu came and told the nurses to continue with CPR, but did not write any prescription or call the concerned consultants of the patient, Mr. Sushmita Mitter, of the patient Sushmita Mitter. Mr. Mitter went on requesting the nurses to contact the consultants, but they did not respond. Ultimately, one doctor, Surangan Das, stated to be the reliever of Dr. Siddhartha Soman Mukherjee from surgical ICU, arrived at 10 a.m. and she issued a death certificate stating that the patient expired at 9:45 a.m. on the same day, that was 30th July 2014, mentioning the time in the death certificate issued by her and that the immediate cause of death was cardia septimacia in the case of metastatic carcinoma ovary. In the death certificate, it was further mentioned another time, that is 30th July 2014, 12:30 p.m. That is possibly the time when death certificate was actually handed over to Mr. Mitter. As the detailed day-to-day clinical records stating the clinical status of the patient are not being provided by the management of the Apollo Gleneagles Hospital, it cannot be deciphered whether from Dr. Such and such Das, one of the attending doctors of Mrs. Sushmita Mitter, could come to the conclusion that the immediate cause of the death was candida septicemia in a patient who was treated from February 2012 in a case of metastatic carcinoma under Dr. Prabhuddha Narayan Mohapatra and operated by Dr. Shubhankar Dev, followed by chemotherapy with chemo post implanted on 18 February 2014. Therefore, it remains a pertinent question as to when Mr. Meter developed the infection, or Mrs. Meter developed the infection of Candida septicemia when she was operated for removal of the chemo port on 29/7/2014 at 7 p.m. That is only 12 hours before her death. Can it be then concluded that she was operated while she was suffering from Candida septicemia? Thus, the immediate cause of death, Candida septicemia, appears to be wrong conceived opinion as to the immediate cause of death. If detailed day-to-day clinical records showing the clinical status and the clinical protocols of the treatment of Mrs. Meter are available, then further opinion on this point of medical negligence can be obtained. But then the next way, from the hospital bills, it is very much evident that the Vasocon 8 ampoules came from the pharmacy on 30th July 2014, and from the statement of pharmacy return that the entire unit was returned to pharmacy. Therefore, Vasocon was not utilized in all probability due to the absence of any doctor or consultant at the surgical ICU at the essential hour, and ultimately the patient expired. From the bills for the consultants, including PN Mohapatra and their assistant, there is no bill for the consultations on 30th July 2014, definitely suggesting that neither the consultant nor their assistant doctors visited the patient on 30th July 2014. That is on the day of the death of Sushmita Meter, stated to be 9:45 a.m. From the copy of your letter dated 25/8/2015, it is evident that though the Doctor Medical Services Apollo Gleneagles Hospital was urgently requested to provide medical records, who received the letter personally and did not respond to the request up till now, though as per the provisions of MCI Code of Medical Ethics, clause 1.3.2, such documents are to be provided within period of 72 hours. This is therefore not only an act of medical negligence, but also suggesting an act of definite dereliction of duty to cover up the faults and negligence of the attending doctors. Then opinion. Considering the aforementioned facts and observations, I am of the opinion that the death of Mrs. Sushmita Meter was due to rash and negligent act on the part of the consultant and other attending doctors and director of medical services, a definite dereliction of duty directing causing death of Mrs. Sushmita Meter. I would like to state that if detailed or day-to-day full clinical records and treatment protocol are provided to me, I would like to give further opinion in this regard. Pausing here for a moment, my lord. This opinion was also on the basis of incomplete documentation, my lord. So far, the factual issue of non-treatment, as found in this opinion, your lordship will see, was repeated and reiterated by the board also. But on certain aspect regarding the cause of the death, my lord, the board differed with this opinion. Now, my lord, the problem with the first report or with the first doctor and the doctors who are in the board was that medical documents are not provided by Apollo. No matter, kindly conceptualize the condition of the patient party then. But I am before a court seeking justice. I seek the documents which I am entitled to within 72 hours of the death of the patient, not provided to me. Court called for those documents, not provided to the court. So therefore, my lord, a definite, categorical, unequivocal statement at the behest of the board is not expected, my lord. And the petitioners, what they want, my lord, they want to take benefit of this. That look, since the opinion is not that assertive, is not exactly the exact cause, so therefore you cannot issue a process against us. You cannot prosecute me. My lord, we have a fundamental principle of jurisprudence that nobody can derive benefit out of its own wrong. It's your institution which did not provide the documents. And therefore, you don't, since the documents were not provided, but the documents were not provided in a case where medical institution was not a party. It's only the doctors who are a party. And therefore, my lord, no board could give assertive opinion. Learned magistrate commented on that.
Yes.
So therefore, my lord, at this stage, my lord, both these reports, my lord, concur on the issue of no treatment at night till my lord, till her death, So therefore, my lord, and case of the prosecution of the complainant is of no treatment. Therefore, there is no doubt, my lord, so far no treatment is concerned. Now, the ultimate, my lord, causation or exact, by the nicety of that will be determined during trial. No matter, very interestingly, I will take your lordship to the medical, my lord, I mean the guidelines, my lord, regulations, medical regulations. Before that, my lord has seen that the allegation in the complaint was, my lord, that from night 7 p.m. till 10 a.m. she was not properly treated. She was not attended even by the doctor. No matter, if I may request your lordship, sees, my lord, the prevaricating stances taken by the petitioners before your lordship's court and different fora, which are on record, my lord. My lord, my lord will give me a moment. My lord's pleasure will be, my lord, to come to paragraph 17, my lord, page 19 of the petition, my lord, 482 petition, my lord. See, my lord, what they have averred before your lordship. No. Page. Your lordship will give me a moment's time, my lord. My lord, sorry, my lord. It's paragraph 18 at page 12. No. My lord, it's my apologies, my lord. It will be paragraph 19, my lord. My apologies, my lord. Page 13, paragraph 19. Well, may I place this? Page 13, para 19. Your petitioner submit. Sorry.
Yes.
If I may place, your petitioner submit. It is apparent from the petition of complaint filed by the opposite party that his wife was diagnosed with cancer in her ovary since early 2012. Since after detection of such cancer, the wife of the opposite party was operated by Dr. Subhankar firstly on 24/4/2012 and subsequently chemotherapies were administered by Dr. Mohapatra. Later in 2013, cancerous growth record for which chemotherapies were resumed after admitting her to hospital. Lastly, on 29 July 2014, Dr. Subhankar performed a surgery to remove the chemo port. After such surgery, her condition deteriorated and she had convulsions, needing medicines to support her blood pressure and was placed on medical ventilation. She was admitted to surgical ICU of Apollo Gleneagles Hospital, where she died next morning. From the petition of complaint, it is crystal clear that the condition of the patient was, kindly, if I may, your lordship can mark wherever your lordship like, I mean, think fit, my lord, but these are very crucial, my lord. From the petition of complaint, it is crystal clear that the condition of the patient was precarious and the doctors under whose treatment the patient was admitted never took all possible initiative under the circumstances to take care of the patient after they were informed of such deteriorating condition of the patient as narrated by Manoj Kumar Kaur. Pausing here for a moment, my lord. It was never the case of the petitioner that the operating doctors were ever consulted. Then, thereafter, if I may continue just this paragraph.
Now, who is Manoj Kumar Kaur?
Manoj Kumar Kaur, my lord, is one of the staff, my lord. One of the staff. But I'm just telling your lordship, my lord, let me take instruction.
Yes.
However, such person has not been. Sorry, Manoj Kumar. Sorry, my lord. Manoj Kumar Kaur is a staff member of, my lord, of Apollo Gleneagles. However, such person has not been arraigned as an accused, but the petitioners who were only authorized to look after ICU has been arraigned as accused by the opposite party number 2. Now, my lord, kindly sees. My lord, page 16, ground 2.
Yes.
For that, my lord, ground 2 kindly sees. For that, petitioners were all along present at the surgical ICU, my lord, which is contrary to the report given by the board, as would be evident from the certificate issued by the hospital. after it was detected by the petitioners, as also other doctors present in ICU, that the condition of the patient was deteriorating, the petitioners did their best as per their complete and job description to overcome the deteriorating condition of the patient. However, in spite of all best efforts, the condition of the patient continued to deteriorate, and finally at about 9:45 a.m. the patient expired. Moreover, the petitioner number 2 finished his duty at 7 a.m. as per the certificate issued by the medical superintendent to whom he was to report administratively, and so was not even in the hospital at the time of terminal events, which started at about 8 a.m. as he had finished his shifts. The said fact was quite under the knowledge of the superior authorities, then is thus passing the buck. So therefore, according to them, they were all along present at the relevant point of time, which was contrary to the opinion of the board, and the condition of the patient was precarious at that point of time. So it was averred before your lordship, in 482 petition. Now, apropos this, if I may just request your lordship to see 2 pages. See, page 229 of the opposition.
Yes.
This was the earlier 482 petition, they have filed before this honorable court, which was disposed of by Justice Bakchi. Because your lordship will have, it starts at page 220. I should have mentioned page 220.
Yes.
Then, sees page 229, ground 2. What was the, before this honorable court, what was the ground taken?
This is the previous petition.
Previous petition, 2464, of 2015, which was disposed of by Justice Bakchi.
Yes.
For that, the petitioners was all along present at the surgical ICU. After it was detected by the petitioners, as also other doctors, patient in the ICU, that the condition of the patient was deteriorating, the patient asked the hospital authority to conduct the senior consultant, Mr. Dev and Mr. Mohapatra, Dr. Dev and Dr. Mohapatra, to provide necessary instruction to overcome the deteriorating condition of the patient, which was again contrary to the report, However, in spite of all best efforts, the condition of the patient continued to deteriorate, and finally at about 9:45 a.m. the patient expired. The said fact was quite under the knowledge of the superior authorities of the hospital, and as such, hospital authorities did not take any coercive step against the petitioners. However, the opposite party number 2, in order to compel the hospital authorities to meet his demands, has filed the instant case. But was the factum of leaving at 7 a.m. mentioned earlier, that was not mentioned in earlier petition. So now this, cosmetic surgery is made in the new petition. Similar grounds are agitated. দেখো তো 94 কিনা আমার হচ্ছে 94 95 and my lord,
Yes.
now the next document, my lord, was filed by the opposite by the petitioners before consumer forum. See page 89, my lord, of the opposition, my lord, only of the opposition, my lord. I will not trouble your lordship with the petition any further. See page 89 of the opposition, annexure R12, written version of PW 1, 3, and 4. And see, my lord, where, my lord, petition opposite party 1, 3, and 4. Appello, the petition number 1, the petition number 2 is a joint opposition filed by them. Well, page 89. before the learned Calcutta District Consumer Dispute.
Yes.
She's, my lord,
Hospital and both the petitioner.
I'm obliged. My lord, she's page only page 94, paragraph 15, which I'll place before your lordship. That with regard to the sorry, my apologies. 94, 94. ওটা হচ্ছে 490
Yes.
well, if I may place paragraph 15 only, that with regard, sorry, my lord, at page 94, my lord has got it, my lord.
Yes.
I'm obliged. That with regard to the contents of paragraph 9, 10 and 11 of the said complaint, the present opposite parties aver that those are wishful after thought of the complainant to malign the opposite parties, hence the same are denied, except which are the matter of record. Matlab thereafter. Fact remains on 29/7/2014 and 30/7/2014, opposite party 3 and 4, but who are the petitioners before your lordship, were on duty for the night shift in the surgical ICU of the opposite party number 1 from 7 p.m. to 7 a.m. of the next day. On 29/7/2014, at around 6:30 p.m., the wife of the complainant had given back from the operating room to the bed, and she was in terminal condition with advanced metastatic malignantia with such and such, the medical term, distending it and preventing her from breathing, for which she was medically ventilated along with severe such and such shock. Due recurrent, but it's again a medical term in recurrence in blood pressure in spite of adequate anti-fluids on which she was on, which has been removed earlier in the evening in ward as the last ditch attempt to control. The patient was taken to ICU when her condition had worsened, and for that she had underwent such and such, it's a medical term again, and was sedated and received multiple, and it's a name of the medicine which constantly thereafter constantly falling, which was constantly falling all through night, specifically since 2 a.m. The complainant and her family members were duly consulted and explained about the patient's such critical condition at regular interval, that would be evident from the clinical notes. But this was again belied by the medical board. Thereafter, the opposite party number 3 left the hospital at around 7 a.m. after completion of his duty and handing over the charge of the patient to the opposite party number 4. And here the case of the opposite part of the first petition was that second petition, or the first petitioner that I was never in charge of. Besides above, it was well known fact that the cardiac arrest is an emergency life-threatening situation which very limited time available to react in order to save life. Hence, doctors went ahead and had taken all best possible steps to save the life of the complainant wife, but all of such steps failed. Well, then again, another stance your lordship will have, the last document I will trouble your lordship with, my lord, page 498 of this opposition, which is, my lord, part of the, rather, my lord, 497 kindly says, of the first petitioner filed before the committee of doctors. Page, my lord, 497. Well, this is the bee's knees, in fact, of this case, since, my lord, it was written by him in his hand and filed before the committee, which exonerated him, my lord. 497. It starts, my lord.
Yes.
My lord, only one paragraph at page 498, the last paragraph, A3. Your lordship will see towards the top at 495, my lord, Nilanjan Indu, I, Dr. Such and such.
Yes, yes.
Such, then, my lord, sees, my lord, A3 at page 498.
Yes. Answer 3.
I'm deploralized. Injection Vasocon, then within bracket malar adrenaline was not needed up to 7 a.m. as BP was maintained with max dose of such and such stated after 7 a.m. stood the pressure was stated that after 7 a.m. the blood pressure was further fallen in spite of high medical support. Pausing here for a moment, there are two things. So up to 7 a.m., according to Dr. Nilanjana Hindu, up to 7 a.m. the blood pressure was normal on medicine though.
Yes.
Then, my lord, in spite of high non-adrenaline support, then, my lord, Vasocon being a brand name is not used instead of instead adrenaline was mentioned in nursing chart. Now, my lord, the medical board found the Vasocon 8 ampule, which was ordered from the pharmacy, that went back. So that was never been administered.
Yes.
So two things, my lord, from this handwriting. One, up to 7 a.m., her blood pressure was okay or at least controlled, which was belied by their statement in 482 petition and, my lord, their opposition before the district forum. And regarding, my lord, administration of adrenaline, it's just the contrary, my lord. So if 8 ampule came, 8 ampule went back, then how could a medicine be administered? Well, there are prevaricating stances.
No, it is the statement of the doctor that,
Nilanjana Hindu, my lord.
yes, doctor, that the adrenaline was administered
My lord.
already. That's why the Vasocon was not used. Adrenaline is in the high dose. That's why the Vasocon was not used. This is the, I think, and
My lord, may I just place it once more, my lord? My lord, just sees, my lord, thereafter. If I may place this.
no
Injection Vasocon was not needed.
Refer the question number
Please.
3. Question number 3. Please
My lord.
state.
Whether injection Vasocon was
Yes.
used in this, please or not.
Yes.
My lord, sees injection Vasocon was not needed up to 7 a.m. My lord.
Yes.
So up to 7 a.m. it was not given, according to him.
As the
The BP was maintained with the maximum dose of non-adrenaline.
Yes.
Now, adrenaline was started after 7 a.m. as the blood pressure was
Because-
fallen.
Yes.
So therefore, my lord, according to him, two things, my lord. Two things are noticeable. A, up to 7 a.m. blood pressure was maintained, which was devastated in 42 petition. Rather, my lord, just the absolutely the different story. That the condition was absolutely precarious. And number two, my lord, that up to 7 a.m. the Vasocon was not given. Vasocon is a brand name. And the medicine is, my lord, the generic name is, my lord, it's a non-adrenaline. Adrenaline is the medicine. I'm sorry, Vasocon is the
That was
brand
the
name.
doctor stated like that.
The doctor has stated, well, who has treated? And he's the petitioner before your lordship.
Yes.
So they have taken, my lord, prevaricating stances before different fora.
Yes.
So according to him, my lord, adrenaline was administered. Then if that was administered, how could Vasocon, which was ordered from the pharmacy, would go back intact? And the last document, I'm sorry, I said this is last, this is just a penultimate. The last, my lord, the order exonerating the doctors by the medical board, but the just previous 2 page, my lord, 494 was the order. Only sees, my lord, observation 3 at page 495.
This is the order of West Bengal Medical Council.
I'm deeply obliged. Then sees, my lord, next page, observation 3 only.
Yes.
Medicine Vasocon adrenaline was not needed as the patient was having very high dosage of non-adrenaline. It was up to 7 p.m., 7 a.m., sorry.
Yes.
So meaning thereby, my lord, this from 2 p.m. to 7 a.m., sorry, my apologies, 2 a.m. to 7 a.m., there is no treatment at all. That's why, my lord, prevaricating stances before different board. Dr. Nilanjan Hindu said before the medical board, yes, I have administered after 7 p.m. I mean, she was administered that high dosage of no adrenaline after 7 a.m. But when the intermediation had went back, my lord, and that was commented by the board even. So, my lord, there are things which are, my lord, contradictory.
Yes.
And your lordship is deciding a 482 petition, my lord, where everything will be decided on admitted facts, no factual, my lord, analysis, or rather, my lord, I will say, my lord, no factual question can be decided. So, my lord, this was the, sorry.
Yes.
No, my lord, since this is a case of, my lord, medical negligence, and this is a case basically of omission, my lord, which I was the other day arguing, my lord, I will place, my lord, few portions from the regulation, my lord, under the medical, I mean, it's the regulation is the medical council, my lord. Your lordship will give me a moment's time, just the exact name I provide. It's, your lordship will give me a moment's time. এটা নেই হয়েছে মানে it's quoted in the complaint. Your lordship will see, just it's quoted in the complaint. Just it's a new book will only not be there. If I just place from the complaint once more, and then I will take your lordship to the judgments, my lord.
Yes.
My lord, your lordship's pleasure will be to come to, my lord, my lord, page 35. It was this is the new act I am having, so this will not suffice our purpose because it was under the old act of 1956. My lord, page 35, paragraph 8. My lord, the first para of 8 I am not reading, my lord, the second half, that your petitioner complainant submits that the Medical Council of India in Indian Medical Council Professional Conduct, Etiquette and Ethics Regulation 2002 has clearly laid down the code of conduct as to be observed by the medical professionals in the course of their work. All doctors are required to give an undertaking in the manner as per the Indian Medical Council Act 1956 while enrolling themselves under the act. Certain relevant portions of the code are quoted hereunder. A physician is free to choose whom he will serve. He should, however, respond to any request for his assistance in an emergency. Once having undertaken a case, the physician should not neglect the patient, nor should he withdraw from the case without giving adequate notice to the patient and his family. Provisionally or fully registered medical practitioner should not willfully commit an act of negligence that may deprive his patient or patient parties from necessary medical care. B, though a physician is not bound to treat each and every person asking his services, he should not only be ever ready to respond to the calls of his sick and injured, but should be mindful of the high character of his mission and the responsibility he discharges in the course of his professional duties. In his treatment, he should never forget that the health and the lives of those entrusted to his care depend on his skill and attention. A physician should endeavor to add to the comfort of the sick by making his visit at the hour indicated to the patient. A physician advising a patient to seek service of another physician is acceptable. However, in a case of emergency, a physician must treat the patient. No physician shall arbitrarily refuse treatment to a patient. However, for the good reason, when a patient is suffering from an ailment which is not within the range of the experience of the treating physician, the physician may refuse treatment but refer the patient to another physician. That the petition, then it's unquote, then it's the analysis of this. And there are other 2-3 regulations. 2004. I have got it. If I may place this from here, page 165. I have placed before your lordship already, my lord. It's 112. One. Give me a moment's time. What I will do, my lord, I will find just take out one of the relevant portions thereof, and in the note I will indicate. My lord.
Yes.
And I will give a photocopy of this for your lordship's ready reference. Now, my lord, coming to this, my lord, if your lordship sees this, the admitted position, what we have as now, my lord, that from 2 a.m. to 7 a.m. she was not attended. Now, my lord, I had placed to your lordship, my lord, the definition of act as in IPC, my lord, the act includes omission. Now, if I may just place
from 2 a.m. to 7 a.m.
7 a.m.
2 a.m. She was in the medical.
ICU, but she was in ICU.
Yes, ventilation.
She was ventilation and she was in ICU.
Yes. So at that time, the non-adrenaline was administered.
After 7 a.m.
No, before 7.
Before 7.
Yes.
Before 7, non-adrenaline.
Yes.
After 7 a.m., adrenaline
The
according to them.
condition was deteriorated after 7 a.m. This is the case. And the doctor Siddhartha Soman Mukherjee was not there.
Who was supposed to be up to 10
Who
a.m.
was supposed to be there up to 10 a.m. It is the statement of the petitioner.
My lord, complainant.
But they denied that we are on duty up to 7.
My lord, issue is that, interestingly,
Yes.
my lord, in the complaint also we have mentioned that from the nurse's desk
Yes.
we have come to know. But it was very sarcastically argued before your lordship that nurse's desk was the source of information. But I was not given any information anywhere at that point of. I could not gather information from anybody. It was only the available information I had. Assuming, my lord, that his duty was up to 7 a.m. First of all, my lord, from 2 p.m. to 7 a.m. Sorry, my lord, again 2 a.m. 2 a.m. to 7 a.m. she was not attended. That was mentioned in the board's report. Number 2, my lord, if 7 a.m. he left by at 7 a.m. then the charge ought to have been handed over to someone. It was not handed over to someone. So the patient was under the guidance of the nurses on, who could not take, my lord, adequate steps. Well, we have this complaint. You also will see the complainant was, my lord, very, very cautious before filing the complaint. Why, my lord? I tell you, lordship, the doctors who operated on, there is no complaint against them because they were not consulted. So since they were not consulted, my lord, that always, my lord, what happens, my lord, the expert doctors, they come from outside, they go back. So if they are not consulted, they cannot be blamed. So they are not made parties.
Yes.
The nurses, they tried their best. No nurse is a party over here, my lord. It's only these 2 doctors and one officer of this, my lord. It's who died also, my lord. Like, who was the, my lord, Directorate of Medical Services of Apollo at that point of time. He passed away in the meantime. So it's not a case that indiscriminately the complainant made persons, many persons accused. It's
Yes.
only the persons, my lord, who are responsible.
Okay.
But should I continue today, or I need to place the judgments only, my lord, and I will distinguish their judgments.
Come on. When?
Whenever it's convenient to your lordship, my lord.
Next Tuesday.
next Tuesday.
Your
As to-
lordship, kindly take up the matter in the month of October, your lordship, because Mr. Manas
No.
will not be
He-
available.
He has not completed. Why are you arguing? You just read it.
But it's 19th only. I tell you, Lordship, the difficulty is that there is a larger bench at 2 o'clock, my lord, where I'll be arguing, my lord. It's the difficulty, my lord.
So, Wednesday, I have 2 PM, separate matters are there.
Can I come at
Thursday.
3 p.m., my lord?
No, 3 PM is not
So
possible.
whenever it's convenient, but I'm so sorry, my lord. My apologies that 19 is that's the difficulty I have.
So 19 at 3 PM, you are able.
But I don't know how long the larger bench will
So,
continue.
when-
But difficulty is that the larger bench may terminate before that also.
So come on Friday, 22nd,
22nd, my lord.
okay, 22nd at 2 PM.
Obliged, my
Special fixed matter. You come with your notes?
lord. Note once I finish, I'll then file the note.
Okay,
my
okay,
lord.
let.
I will finish on that day, my lord. I will place my
No,
judgments.
Let them reply thereafter.
Thereafter, my lord, that will
Thereafter-
because otherwise again, my lord, note after
Yes,
my lord,
yes,
you also have seen in that matter, my
Yes,
lord,
yes.
additional alteration of notes. My lord.
Very well. Please take down. The argument on behalf of the opposite party heard in court. The matter is a important matter. So list the matter for further hearing on September 22nd at 2 PM as a special fixed matter.
Deeply obliged,
Yes. You take that your book.
my lord. I'll give a photocopy of the relevant regulation, my lord. That will be better instead of handing over the entire book. My lord, may I take your lordship's leave? My
Yes.
lord?
Do you want this, Mr. Ajay Kumar Gupta?
My lord, that your lordship may retain in the record. My lord. Because that was earlier handed over. I don't know, my lord. I'm not sure. I'm not finding it. That's why I have brought this additional copy. But in any case, it was before the learned magistrate, your lordship.
Very. It is with the record.
It was with the record because evident from the expert's report that it was annexed E to the
Yes.
report which was placed before the
Yes, annexed E is there.
Deeply.
কল করতে হবে।
appellate.
27 and 28, both matters are there.
Kindly pass it over when I am calling.
Very well. Yes. 33.
33. She lordship, the case before your lordship is the death case. And against the order of dismissal, I have come before your lordship. It has been dismissed on the ground. The mother is a claimant before your lordship. The case under section 163A, the dismissed only on the ground. Lordship kindly turns to my paper book. Upon lordship will find that paragraph, page number 27 starts from paragraph page number.
Yes.
First page of page, lordship kindly page 27 of my paper book.
Yes, got it.
The last paragraph, the opposite party number 2, Oriental Insurance Company Limited, contested the case by filing written statement, wherein each and every allegation brought by petitioner denied, then content inter alia that instant case is maintainable. The opposite party denied that the victim died motor vehicle accident, their evasive denial is there, involuntary accident. He has been further stated the opposite two, the victim himself was responsible for the accident. He was not working. So, and the service and his monthly income also rupees 3,300 other incident, that is also been denied. And Lordship kindly turns to page why the learned tribunal dismiss my case. Lordship kindly turns to page turn to page Lordship 29, judgment in page 3. Last paragraph before the ordering question. Upon hearing the learned advocate the both sides and considering the materials, evidence, and record, we find that now one, Najmul Sheikh died in a road traffic accident caused by the offending truck. But here I find that the petitioner has failed to produce any document to show that at the time of accident, the offending vehicle was insured, should be insured with the valid insurance policy. Stop. The Xerox copy of the insurance policy which was submitted by the petitioner does not bear the number of the offending vehicle. From the said policy, it cannot be held that the offending vehicle was insured with the valid insurance policy as claimed. So that is my case. So Lordship is the new vehicle. Actually, it is the new vehicle. If Lordship will purchase a new vehicle, then after completion the registration number will provide. After completion the insurance, then registering authority will provide the registering number. Then Lordship kindly see here I have also annexed the kindly come page 21. Lordship just come. The insured name is Mr. Mohan Prasad. That is also the name, and the charge sheet FIR also there. I will show. And then Lordship kindly come to the 1/3 portion of this policy copy, that the registration mark and place. Let's kindly see the new.
Yes.
So with the new vehicle, that policy the number cannot be, they provide the number. After that, as and when it used further, then the number will come. So ultimately the chassis number, engine number is there, the insured name is there. So under that score, Lordship, here I also take some help to Ms. Rasmosi. There is the policy is issued in such way. If the new vehicle, Lordship will not find the vehicle number. But Lordship kindly turns to page 9.
Yes.
Yes, Lordship. Let us kindly page number 9.
Now, here the insurance registration number was not given
There is no.
in
What
the insurance certificate.
What the reason? The case was dismissed. But Lordship kindly the name. You kindly see the name of the insured on my claim application. Page 2 of my claim application, column number 16.
The name of the
Column
owner.
column number 16, Rasif got it. Mohan Prasad.
No, is it the same vehicle?
Yes, it's the same vehicle. It's the same vehicle. His name also appearing in the policy copy is Mr. Mohan Prasad.
But the police seized one insurance certificate containing the number of the vehicle,
Yes,
That's it.
containing the number of the vehicle.
page 14.
Page.
Seizure list.
Yes, there is a number. After issuing the policy, the accident took place.
So
But
where
there
is
a
where is
number has
the
come in the page 14, Rasif, yes, column 3. I have also noted the Jharkhand both vehicle, the JH50B 2051.
But the policy doesn't
But the policy doesn't reflect the number because of the vehicle is a new vehicle. And that is new is there, new,
seizure list dated 17th of November 2008.
yes,
So it is item number 2, insurance certificate of WB 38H valid up to.
no,
Yes.
not WBH lordship, W is the defined vehicle, column number 3 lordship, kindly see, page 14, column number 3, property of the description. Jharkhand lordship, kindly see, this is a very, Jharkhand, page 14, FIR, formal FIR, final report.
Page 14.
Page 14, lordship, kindly serial number 1 to 3, property of the property description.
Yes, item number 6.
Item number 3,
No, we come to item number 6.
yes, insurance certificate,
Yes, WB.
that is the different, another vehicle,
That is separate vehicle.
that is separate vehicle.
So there are two vehicles involved.
Two vehicles are involved. So my complaint against the vehicle of Jharkhand.
Against the vehicle of Jharkhand. That
Against the
is
vehicle of Jharkhand. Then let's kindly see the column 3,
column 3 is the RC book.
RC book, yes, RC book of J05B 2051. That's it, got it. RC book of JH Jharkhand 05B 2051.
Now, what is the case? What is the case? Two vehicles are involved.
Yes,
What is Tata Sumo and another is?
yes, another is the Lord truck. Brief fact is this, lordship, kindly transfer to the judgment page 27. I am placing. At about the victim was working under the Reliance mobile fixing cable. And one truck bearing number JH number 2, driving by his driver rash and negligent test and said the victim as a result sustained injury and shifted to STS and local people. The lordship come to the decider.
No, so why that is the JH?
The JH.
So why RC book of another car was seized?
The victim was working under the fixing one truck. Kindly turn to page 13. FIR. আমার পিএসসি নিবেদন এই যে
page 30.
পেজ 30 আমাদের আমার সাথে আমাদের গ্রামের মোহনসের 20 বছর পিতা সচিন একই সাথে কাজ করছিলাম। আজ ইংরেজি 3/11/2000 তারিখে আমরা একসাথে কাজ করছিলাম। তখন কল্যাণেশ্বরের দিক থেকে একটি 10 টাকার লরি মাল বোঝে জাহাজ নম্বর JH05B2051 অতি জোরে বেপরোয়া হয়ে আসিয়া এসে সোজা একটি টাটা সুমো নাম্বার যার পিছনে ধাক্কা মারে মোহন শেখের মাথা পিষে অতি জোরে বিপরীত সতর্কভাবে আসিয়া সোজা এসে একটি টাটা সুমো নাম্বার যার নাম্বার WB এর পিছন দিকে ধাক্কা মেরে মোহন শেখের মাথা পিষে দেয়।
So the offending vehicle what?
Was the truck JH Dhaka
JH.
JH. My claim against the JH.
So you are showing that the page 21 is the insurance certificate of the JH
JH
of the truck.
But registration number is not there, right?
Oh, no. Registration number থাকে কি? Two vehicles are involved against the truck. I have lost the complaint. I have lost the claim case, and claim case was dismissed only on the ground. The new vehicle number was not showing in the policy. But I have supplied the number of policy. Everything I have supplied. Just kindly turn to page 9. That is the evidence that the said equation of paragraph 5, last digit of the policy, there is some mistake of bearing number JH05B212051 by mistake typed it in 0 1 place. Actual last digit is 9. That the policy number is wrongly typed as such and such. After that is corrected the same. But also kindly see the policy number which have come evidence, and policy number is appearing in the before your lordship 8549. Policy number is there. And in the claim application also I have mentioned the policy number.
Whether this policy was seized?
Yes, that policy was seized. Victim, RC,
No, my lord, this policy was not seized.
not seized, but the vehicle was seized. Vehicle was booked. Vehicle was in the charge sheet was submitted against the offending vehicle, driver of the offending vehicle, and owner name is appearing also in the policy as well as in the claim application. And that is the RC book of JH number 05B2051 in the name of the Mohan Prasad. So you kindly see that the name of the owner name also appearing in the final report charge sheet. Mohan Prasad.
Yes, the Mohan Prasad is the owner.
Owner of the offending vehicle.
But whether this policy is for the truck,
Yes,
this is the question.
this policy of truck. Let's kindly see the policy copy. Kindly come to a copy of the policy.
That is why the learned tribunal did not understand the issue.
Tata LPT 252 is a truck. Tata LPT Smith truck. Kindly see. Learned tribunal only on the issue that the number is not there. My humble submission, number in new vehicle, number should be. If today I purchase the car, then I will get the number of my vehicle in the policy copy. In the next year, as and when renewed the policy, I will get the number. Because of after completion of the all.
Nowadays,
Nowadays registration is done, then we will get the number.
So as and when I purchase the car, I will get the policy with the new, because on that, after completion of the entire procedure, after the policy, other procedure, then registration will issue the number. If I have placed the copy of the policy before the registering authority, the registrar will not issue the number. This is the fact. In every policy, new after purchase, at the time of purchase of new car, the number will not appear in the copy of the policy. But name of the insurer has been appear in the copy of the policy, Mr. Mohan Prasad. That name is
No,
appearing
Mr.
here.
Mohan Prasad may have separate cars, separate vehicles, separate trucks.
No.
But whether this truck is for the,
Lordship, kindly see the RC book of JH sir in the name of Mohan Prasad. There is the police report. Lordship not got it there. Page 14. Page 14, column 3. RC book of vehicle number such and such in the name of Mohan Prasad.
yes,
So then Mohan Prasad name also appearing in the copy of the policy. That name is Mr. Mohan Prasad. And
no,
filed-
I say that the Mohan Prasad may have separate other vehicles. That may be the number of there, but
Mohan
whether
Prasad,
this
no.
policy is that for that truck, how can I ascertain? How can the tribunal will ascertain that this policy is for that truck, for the offending truck?
Lordship, these policies
Only
are
for the name.
Only the insurance company, if they assist the court, if they they have issued the policy in respect of that vehicle, or also issue, they are also given the engine and chassis number. The insurance chassis number also appearing.
Yes. Insurance and chassis number is
It's
also.
also appearing.
If I have the RC book, then I can ascertain.
The learned tribunal could not assess whether.
Yes,
this
that is
policy
the issue here.
Because the RCB book was not filed. The chassis number and engine number have been matched with the policy then. If you have filed the RC book, see whether you have the RC.
RC book not with me, but Lordship, it appears from the final report that RC book has been seized by the police, and the vehicle number is also given, and the
Yes,
name also
RC book
given.
was seized and it was produced by the owner.
Yes. It's produced by the owner, and name also in appearing in the Mohan Prasad in the copy of the
No,
policy.
only the naming the person is not the sufficient. The person may have another truck, another more truck. That is why the tribunal rejected your claim. So how can it be ascertained right now? So your submission is that this is the new policy which was issued at the time of purchase. Okay, so afterwards the policy must have the number. The insurance company may provide the number.
So ask the insurance company to place that policy and other policy. Easier for the claimant to.
Very well, I am directing.
My lord, the owner could have filed the policy after this, not this previous policy, the policy which has been issued in the name.
Owner may have not contacted with you, may have go with the national insurance company, may have another insurance company. Okay, so you ascertain.
The chassis number and engine number, if it has been matched with the RC book.
Yes, it can be, but it is not with you. So you just ascertain from your office, from your document, from your stock computer, that whether this certificate was issued in the name of this WB such and such. Okay, JH.
This can be done.
If this be the initial policy, thereafter the policy is there.
Yes,
The
yes,
final policy is
obviously.
there.
Yeah, as and when he is renewed the policy.
Yes.
Usually.
Very well.
Lordship, yeah, as well as he renewed the policy, the chassis number, engine number should not be changed. That will also.
All will be there.
So it can be.
No, not at the time of renewal. it may be that for the 1 year, the Mohan Prasad may contract with the Oriental Insurance Company. Next year, he may be with another insurance
Another
company.
insurance.
Okay, so it is not necessary that he may be always with the Oriental Insurance Company. Okay, please take down. The instant appeal is preferred against the judgment dated 16 September 2013, passed by the learned judge Motor Accident Claim Tribunal, Asansol, in MSC case number 65 of 2010, stroke 02 of 2009, under section 163A of MD Act. Stop. A truck bearing number JH-05V stroke 2051 was arrayed as an offending vehicle in this case. Stop. The truck was alleged to have been insured under the policy of the insurance, what is the Oriental Insurance Company Limited. Stop. The policy issued for the time. Policy covered
1st February 2008,
from 1st February 2008 to
31st January 2009.
31st January 2009. Stop. The number of the policy was mentioned as 333 stroke 31 stroke 2008 stroke 8549. This is the number.
Yes.
And Lordship has also mentioned date and place. Place Jamshedpur, dated 1st February 2008. That is the bottom.
Okay. The policy number. The issuing office is DO Jamshedpur. Wide office code number 33300. Stop. The policy copy was annexed with the paperwork. Stop. The policy copy doesn't contain the number of the vehicle, registration number of the vehicle. Stop. Considering the situation, to dispose of the instant appeal, it need to ascertain that whether the offending vehicle bearing number is covered under the policy of the Oriental Insurance Company Limited for the period mentioned above, while the policy number as mentioned. Stop. The learned advocate for the Oriental Insurance Company Limited is requested to take necessary instruction from the office concerned and submit a report to the report. How many days?
10 days.
10 days. Very good. This is the matter. 28th of September for filing report by the learned advocate for the insurance company and for further order.
Paperwork file kept.
Yes.
Paperwork file and kept with the request of the procedure. The policy. First, can you stick online the paperwork file?
Paperwork may kept it.
Thank you.
Yes, one matter is pending, Mr. Satra. (27) and 28.
My lord, Mr. Satra, what is appearing in this case? He has gone for a case, one of his matter is called for, so kindly give me short pass over, 5 to 10 minutes, he told me.
In which matter?
And 27 and 28. I am for the appellant. Mr. Bhattacharya is appearing in this case. So he told me that he has one of his cases called for.
Mr. Bhattacharya for on behalf of the appellant.
On behalf of the
Appellant.
Yes.
He was there here.
He was there right now. One of his cases
One
called.
fixed matter has been called.
Yes, fixed. Just 5 to 10 minutes. my
Okay,
lord.
just wait. Just wait. Call next matter. No, wait. No, wait. Let it be on 34. We have on 33. No, call 34. Next.
I am also engaged on behalf of.
Yes,
I am for the,
36, the appeal of the Union of India.
yeah,
And 37 is the appeal of the claimant.
It's a counter appeal.
Yes,
actually,
two appeals are there.
appeal for interest, it was awarded by the Honorable Tribunal.
Paper book is handed over to me yesterday,
My lord,
but as it appears that paper book is incomplete. The second appeal's memo is not there in the paper book, and the annexure of that is the DRM report, annexure of the WS filed in the tribunal, that is also missing. And the deposition of PW and PW2, those are very important. The judgment is very much relied upon. That is also missing. Paper book, I think, is incomplete.
my lord, this is the paper book, informal paper book as was ordered by your lordship. And that has always served to them also. Written statement also. DRM report on that time, what was not the rules. DRM report after that.
But the deposition, PW1, PW2.
PW1, PW2 has been discussed in the original judgment.
Yes, so
Judgment has been, it was discussed.
that's why it is needed.
Judgment, it has all been discussed. And it is
No, no,
admitted.
whether you have incorporated this.
No,
Why not? You don't have the copy? Why you not incorporated the PWs?
Actually, my lord, this was filed by the R.K. Mittal, who has already died.
No, you don't have the copy.
I don't have the copy right now because he has died. Really filed the appeal. And this was actually dealt with by R.K. Mittal, who was unfortunately died of corona.
yes, Rajendra Kumar Mittal is that
But
recorded.
contents of the appeal is the self-inflicted injury. Paper book 32. Contents of the appeal. May please see. 31, 32.
And also memo of the counter appeal is not there.
That was filed by R.K. Mittal. That appeal is not there. We are working filed for interest. That was actually on that last day. It was discussed here. My lord was pleased that interest is not the factor. That appeal is not very important here. Appeal is only important here. What is the realization actually implicit appealing for on the ground of self-inflicted.
No, what you incorporated in your memo, in your paper book. Application for claim. Written statement.
Yeah.
Judgment. Memo of appeal by your memo,
By the railway.
It is
by the railway.
Railway.
And where is your memo?
My memo is for interest.
No, where is your memo? You have, whether you have incorporated this memo in the paper book, not.
No. No, memo of appeal is there.
and also no deposition.
Actually,
I think
appeal was
supplementary
filed by for interest.
However, maybe the memo has to be incorporated with this.
Appeal is not available. Actually,
You don't have the copy of memo?
no,
Your memo?
no, actually, memo is, appeal is not there, but can is there.
No, can is not there. Okay. The application. I want the memo of appeal.
That was for interest only.
However, maybe.
Last day, my lord, you pleased to say that interest is not the matter. I agree.
But the deposition should be incorporated. This is very important, because the judgment itself contains lots of points on the basis of the AW2. This is very important.
Deposition can be available from the LCR.
Yes, but
Deposition only one thing that
paper book should contain.
falling from the running, that is the only point of issue here. You are only telling this is the self-infringing, but Supreme Court is very clear about the matter.
No. FMA, give me the FMA 1110. Now 1110. There are as well as 13 grounds, sir, in the memo. Not only interest. There are several grounds.
Only interest.
Not only
That
on
was
interest,
awarded by the Honorable Tribunal. We filed for interest.
not for only interest that also. The law speaks otherwise. So
Actually,
how you can complete? How you can
actually,
complete?
I have got no sufficient knowledge of the apple because I
I
was,
understand, I
I
understand.
was
So,
not that time on
so
that time.
how can it be taken completely? It has to be taken completely, otherwise it
Supplementary
cannot.
paper book.
Yes, supplementary paper book, you have to file supplementary paper book by the next day. If you want something, I can assist you from the LCR. Okay? That will be
May
better.
may please order that
Not necessary to pass an order.
for that copy of the memo.
Yes, you just take the copy. I am passing the order. That's because it is pending since long. I want to dispose of it.
My lord, deposition is not here, only can be available from the LCR.
Paper book has to be prepared along with the all pleadings and proof. So strictly we cannot go by like that. So you just file one supplementary paper book. Okay.
But may please order for the
That has been stated in the recorded in the judgment. But it is not relevant. That may be relevant
Yes.
with in the appeal also.
For that reason, the union may go to the Supreme Court. You know, they don't have any option to go by. You have to be very cautious in those matters. Otherwise, you would be suffer. This is the issue.
You have to certified copy of
Yes.
may please order for the LCR, calling for the LCR from that time.
LCR is here. Everything is here. Okay, you just take the copy and file a supplementary paper book. Okay. So, what is the requirement? The memo of appeal of memo of appeal.
FMA Tribunal 0 of 2015.
Now, why you stated in the memo of appeal file in court being FMAT or FMAT number was given?
Initially it was
FMT number.
আবার তৈরি করতে হবে। অবশ্যই একটু তৈরি করতে হবে।
এটা হচ্ছে এইটা, একটু সময়
Okay, please take down. Informal paper book filed on behalf of the claimant is taken on record.
Claimant and appellant.
Okay, taken on record. It appears that
আমি
The-
ইন্টারেস্টেড অ্যাপিলেন্ট।
the depositions of the witnesses, including the memo of appeal of FMA number 1110 of 2015 is not incorporated. Only this is only, yes, that is
And-
deposition.
and also the annexure to the
Is there any annexure of the WS?
there should be annexure in the WS. That is also
not mentioned in
WS.
with the WS there should be an annexure.
স্টেটমেন্টে কিন্তু বলা নেই কোনো অ্যানেক্সার আছে বলে।
Statement যেগুলো আছে সেগুলো
পেজ 19
If there is nothing, then no problem.
এই যে ডিটেইলসটা
এখানে কোনো বলা নেই কোনো অ্যানেক্সার আছে মানে এখানে কিছু
If
বলা
there
নেই
is no annexure, there is no problem. But usually DRB report is incorporated in the
যদি থাকে ইনকর্পোরেট
Yes, submit, my lord, one thing regarding the DRM report. So though the rules was there,
That no such report is filed.
No. Rules on that time, that was not the rules. That comes of 2004. But really did not file a DRM comments. Even that rule was there also.
sometime just the railway passenger manner of investigation of untoward incident rules 2003. These rules comes into effect from 2003, but no such inquiry was done.
That was the lapse of the part of
Whether-
respondent railway.
whether
They
in-
did not do it.
whether in particular case DRB was there that the
Annexure event, annexure event.
No, DRM comments.
Very-
স্কিপ করে দিচ্ছি যদি থাকে ইনকর্পোরেট
Railway did not give it. That time that was, railway was not strict enough to.
15
And-
is not incorporated.
Present they are doing
The right people.
There is a lapse of the respondent.
No, the WS doesn't contain any annexure. Is not incorporated with the paper book. Accordingly, the claimant is directed to submit a supplementary paper book incorporating the above mentioned documents. After receiving the same from the office, from the concerned office, receiving the certified copy of the same from the concerned office, after receiving the certified copy of the same from the concerned office, by September 29, is it possible? Receiving certificate copy and, okay. List the matter on September 26. The, so taken on question, the paper book. Question. September 29. Great.
Alright.
Yes, item number 27, 28.
27, my lord.
Yes.
But in this case, my lord, I am for the accident. My lord, this case is a very simple case, but however, it was dismissed by the learned railway claims tribunal.
Why?
The reason is that it is a death case, man. The person who died, from his possession, one monthly identity card and one monthly tickets were recovered. But in those, mainly in this ground, that the monthly ticket and in the identity card, both of them did not bear
the signature of the person. This is the reason. Did not bear the signature of the person, and another thing is that they're also saying that in the identity card, which was issued in the year, my lord, 1995, there it does not bear any stamp of the issuing authority. But both are recovered from this. And this another thing, my lord, it's a ticket. Is a computer general ticket, and my lord, here the name of this person N. Devnath is printed in the ticket, and the ticket is, my lord, page number 61. Page number 61 of the paper. Now, my lord, in this, for this reason, the learned tribunal.
Show me the judgment.
Yes.
Refer me the page.
Kind of relevant portion is 46,
Page
47,
number 43, my lord.
46 and 47.
No, page number 43. Page number 43, kindly come. My lord.
Yes.
Page number 43, paragraph number 1, 4, 5, 6. In the above circumstances, I am of the opinion the applicant had been able to prove that the disease was a bona fide passenger. To get a claim in railway claims tribunal, my lord, two criteria must be fulfilled.
Yes.
One is that with a bona fide passenger, and the incident is an untoward incident. So it has been proved
That he was the bona fide person.
yes, my lord, learned court is at learned tribunal is admitting in paragraph number 6.
So issue number 1 was decided in your favor.
In my favor, but my lord, then my lord, again in page number 46, my lord, kindly come to my lord, to page number 46. Page number 46, Roman 6. Here, the learned tribunal is coming into the conclusion. This is a knockdown case and not falling down from the running train. It is the argument. It is the argument of this. When the counsel for respondent during argument made the following submission.
Yes.
It's 47, last paragraph. Statement of
Now, my lord,
last line.
in this matter, we have adduced eyewitness. This AW2 is the eyewitness. AW1 is the wife of the deceased, and she is admitted that she has not seen that.
Very well.
This AW2 statements, the statements of AW2 in para 10 is affidavit that he went to the station master's office and told him about the incident, and the oral evidence of AW2 is annexed. Well, I'm coming starting from item number 2, the serial number 2, the oral evidence of AW2.
It is better to read the PW or AW2 first.
Yes.
Come to AW2. Where is AW2?
Yes, I'm coming.
22.
Cross examination is 18.
No, what is the 18? Yes, read out the 18. Chief.
Yes. Affidavit in chief. I, Dhruva Chakraborty, son of Dipen Chakraborty, aged out 35 years, by faith Hindu, by occupation service, residing at so and so, do hereby solemnly declare follows: that I have received a notice of advocate, etc. That on 18/10/2004 morning, I left my house and reached Ichhapur station, and thereafter I boarded a local Shialda bound train from Ichhapur station to reach Shialda with an intention to attend my regular workplace. That on the same day, that is on 18/10/2004 evening, after completion of my office duty, I came to Shialda station and boarded in an up local train compartment from Shialda station at 7 p.m. to return back to my house at Ichhapur.
Yes.
That soon after I boarded, I saw one person wearing stripped half push shirt was trying to enter inside the compartment. And when I turned around, I saw that the person was Nonigopal Devnath, and he was known to me, and both of us often used to travel together in the same train.
Yes.
That the same compartment was very much overcrowded, as it was a packed time when many daily passengers returned back to their respective homes after completion of their duties, and also there was sellables, luggages, and baskets thrown by the vendors near the door, of the aforesaid compartment, and only few people, including me and the said Noni Gopal Devnath, could manage to board at the same train compartment. That soon after the train departed from the platform of Sialda station, both of us endeavored hard to enter inside the compartment, but found it extremely difficult to enter inside the compartment, and we could only manage to enter few feet away from the door of the compartment, where jostling among the passengers were going on continuously. That in the process, when the said train just departed from Agarpara station at about 7:45 p.m., both of us approached near the door of the said compartment, and the said Noni Gopal Devnath stood at the threshold of the said compartment as he had to get down at the next station, Sodhpur. I stood just behind him at the side of the door of the said train compartment when the said train arrived near kilometer post number 14/24 station. Due to tremendous pressure of jostling near the door and the heavy jar due to sudden application of brake, the aforesaid Noni Gopal Devnath's hand grip went adrift, and he fell down from the said compartment in front of me and got rammed on the nearby post on the said place of occurrence.
Yes.
That at the point of time I heard a scream from its person who stood just beside me and who had also seen the whole incident of the accident, and both of us claimed for help and asked the inside passengers to pull the chain. That soon after the train arrived at Sodhpur station, I got down from the train and tried to go to the place of occurrence. But some co-passengers who also got down from Sodhpur told me not to go to the spot without intimating station master and police. That subsequent thereafter, I along with two co-passengers who on my request agreed to help me, went to the station master's office and told him about the incident, and after being advised station master to be rushed to Damnam GRP and informed about the incident of the accident. That in the meantime, I intimated the whole incident to Noni Gopal Devnath residents over telephone at about 8 p.m. and told them to send their relatives to Damnam GRPs. That subsequent thereafter, the investigating officer, namely Sri Molay Kanti Dotto, recorded our statement in writing, and thereafter I, along with the said co-passengers, waited for some time at the police station till the arrival of the victim's relative, and subsequently his relatives arrived at the police station, and I, along with his relatives and said co-passengers, went to the place of accident, and where I and his relatives identified the dead body of Noni Gopal Devnath, the said investigating officer recovered some documents and wallet containing money and also a monthly ticket from the victim's pocket. Thereafter, I and other two people were asked by the state investigating officer to sign in the place of piece of paper at the place of occurrence. Later, I left the spot and went back to my house. That statement went following paragraphs. So this is the statement. Now, my lord, kindly come to page number 22, cross-examination.
Yes.
I have my voter's identity card as proof of my identity, original code. I have been working in Exide at Shamnagar from 2005. Before that, I was working in Bhattacharya bookstall at Sialda from 2003 to the middle of 2005. I cannot remember the exact date of my joining at Exide. I cannot also remember the date of Durga Puja in the year 2004-5. I know the contents of the affidavit. I have signed it. I knew that this is Noni Gopal Devnath 6-7 months before his death. He was residing at Sodhpur, Bhola. I am not aware about the house number or the road number, except his wife. I do not know whether any other members are there in the family. I have come here on getting notice from S. Sinha, advocate, letter shown. The wife of the deceased did not tell me to come here. At present, I have no document to prove that on the date of incident I was traveling with the victim. I was traveling from Sialda to Sodhpur. There are 4 stations between these 2 stations. It takes about 40 minutes to reach Agarpara from Sialda. On 18/10/2004, we boarded Kollani super train from Sialda at about 7 p.m. It was a galloping train. It first stopped at Damdam at about 7:25 p.m. Then it stopped at Sodhpur at 7:35 p.m. The train did not stop at Belghoria and Agarpara station. Contents of paragraph 7 of the affidavit has been explained to me by the advocate. Except the victim, no other known person was traveling with me in the said train. I informed the station master Sodhpur about the incident, and I signed there. I went to Damdam GRP at about 10:30 p.m. I did not sign the inquest report. I did not sign the inquest. Police recovered the parts from the body of the victim. I cannot say whether any scissor list was prepared by police. It is not a fact that I was not traveling with the victim on 18/10/2004. It is not a fact that I was traveling with the victim. I mean, what is this? I cannot say whether the scissor list was. It is not a fact that I was not traveling with the victim on 10th
It is not a fact that I was traveling with the victim on this. I think it is a some misrepresentation, my lord. Or some.
Okay.
It is not a fact that no such incident took place. Actually, it is a denial. My lord.
Yes.
Denial of fact. It is not a fact that such incident took place on that day. No such incident took place on this day. It is also not a fact that I have given the false statement as per advice of the advocate just to get some money from the customer. To quote, I was coming from Shialda to Sodhpur. I was at that time working in a bookstore at Shialda. I have no document to prove. So, my lord,
So on the basis of that, deposition, what is the observation of the learned tribe?
On the basis of this observation, the learned tribunal stated, my lord, examining the evidence, including documented evidence submitted by the applicant, the pleading of learned counsel of both sides, the following points were cited. Did you? Yeah. Did you?
No, you read out the page 47.
Yes. In the claim application, there is no mention of Dhruva Chakraborty. Means this eyewitness, name of this eyewitness is not mentioned in the claim application. The alleged eyewitness in this case, however, in para 10 of the applicant's affidavit, the name of the alleged eyewitness Dhruva Chakraborty has been introduced by the applicant. Further, no amendment petition has been filed before this tribunal for including the name of the alleged eyewitness in the claim application, and itself creates suspicion about the oral evidence being adduced by the applicant. My lord, a person is adducing evidence before the learned court, taking oath, and how in the cross-examination, in proceedings, there is nothing has come out against his statement. They have failed to break this witness, and even after that, how the learned tribunal can come into the conclusion that this person was not present over there. He has stated everything, number, sessions, everything, and no contradictory evidence also adduced by the. No evidence at all. No evidence was adduced by the railway. Now, oral evidence of AW2 is analyzed under. In para 9 of the affidavit of AW stated that after the train arrived at Sodhpur station, I got down from the train and tried to go to the place of occurrence, but some co-passengers were also got down at Sodhpur and told me to go to the spot without intimating, not to go to the spot without informing the station master. Firstly, a normal reaction in such case is to find out whether the person is still alive or not, so that he can immediately be taken to the hospital. So informing the station master for seeking this help is understandable, but then not going to the place of occurrence to see that severely injured person is taken to the hospital or strange and create suspicion. More so, AW2, who was going back to the house at Ichapur specially, got down at Sodhpur after seeing the incident. Hello, this inference drawn by the, I fail to understand how
Yes,
the learned court has drawn this inference.
Yes, read out next.
The statement of AW2 in para 10 of his affidavit that he went to the station master's office and told him about the incident is not corroborated by the railway memo issued by station master Sodhpur, which has been treated as FIR. There is no mention of Dhruva Chakraborty in the memo. The information to the station master was furnished by the gateman, BLC gate number this, that and such, and 2, that an unknown male agent about 30 was knocked down. But my lord, in every case, railway authority take this defense that a person with bona fide passengers, now where the learned tribunal has come into the conclusion that yes, he was a bona fide passenger, how it can be, it come into the conclusion later on.
Okay, very well. Next.
That he was knocked down. A bona fide passenger, he can fall down from the train. He cannot be knocked down by the train. AW2 as per statement in the affidavit of eyewitness to the incident as per para 11 of the affidavit, he rushed to Downham GRP and statement was recorded by the investigating officer Sri Molay Kanti Dotto. He remained at the police station waiting for the relatives of the victim to come and went to the place of occurrence with police. Even then, his name does not figure in the witness in the inquest report, which creates a reasonable doubt whether he was present at the place of occurrence, and even he was an eyewitness up to the incident. The inquest report reveals that the proper investigation, it seems that they see the person fell from the fast moving train. The witness also agreed that it is understood from the inquest report that the investigating officer and also witness also agreed with him were not definite and only presumed that the victim fell down from the train. This clearly implies that the witness who had signed in the inquest report and also the persons present there were not eyewitness. The above further confirmed that AW2 was not present. AW2 admitted that he didn't sign in the inquest report in the place of occurrence. Had he been in the Domdom GRP station as stated by him, his statement recorded by the investigator officer Malakantu Dotto and then accompanied by police to the place of occurrence, his name would have been figured in the inquest report and the investigating officer would have been definite and specific in the inquest report. The victim fell down from the coal line super train as deposed by the during cross-examination. Without bringing any witness, without bringing anything out from the cross-examination, how they can come into this conclusion, such a conclusion that I have perused the judgments are not judgments. Perused the judgments are not in view of the aforesaid discussion. The evidence of AW2 by the applicant was an afterthought, as his name did not figure in the four corners of the claim application. The oral evidence of AW2 raises reasonable suspicion. Well, how the suspicion is coming out? The question of suspicion is coming out from the evidence. I failed to understand the genuinity of the statement. In fact, I have reason to believe that the evidence of AW2 is truly built up by subsequently for this case. Now coming to the documented evidence filed by the applicant, death certificate reveals that Dhoni Gopal Devnath had died on this. The instant case, the inquest report, which is based, which is the basic and very important document, was not filed by the applicant. Thus, the summons were issued from the court side for production of the inquest report for proper adjudication of the case. Inquest report that after proper investigation, it seems as if the said person fell down. Inquest report reveals that after proper investigation, it seems as if the said person fell down from the fast moving train. Kindly come to page number 49, my lord, paragraph number 3. That after proper investigation, it seems as if the said person fell down from the fast moving train. The witness also agreed. It is evident from the investigation that the investigation officer also witnessed. Also, the witnesses were not definite and only presumed. So, it is a case of civil in nature, my lord. So, the principle followed by for adjudication of this case is preponderance of probability, not beyond reasonable doubt. This is not a criminal case, my lord. And that should go, as it is a social welfare legislation, social beneficial legislation. So, such inference will go definitely go in favor of the, my lord, the victim. My lord, I am pressing emphasis upon this point, my lord. It is 49. Inquest report reveals that after proper investigation, it seems as if the so there is something is there. Was there?
Show me the inquest report.
My lord, this inquest report was not because it does not came into our hands, my lord. It was called by the learned court, and we didn't receive any copy of that.
It was not exhibited?
It was exhibited, my lord, but my lord, we have perhaps it is in the record, my lord, but that was not given to us. Exhibited. Oh, inquest report was not exhibited. It was not exhibited. That is why we inquest report কোথায় লেখা আছে? Page number 45, my lord. 45. Page number 45, my lord. Just stated. In support of a case out of the judgment. Page number 45, my lord. In support of the case, applicants file the following documents: court certified copy of police report, original railway card number, please, original market session, original death certificate, copy of abstract police report, copy of PM report.
Yes, inquest report is there.
There. No, আছে তো. Exhibited. Exhibited. It was not exhibited.
LCR আছে?
Yeah,
Where is the inquest report?
Inquest report, my lord, we have not received the copy. LCR for in my lord, LCR में kindly report.
What is in page 60?
Abstract police report. Abstract police report, finally. A1 is the, my lord, 859 is the final police report. It's abstract of police. That's it.
No, result of the inquest. Just come abstract of the particular report of the police, and thereafter, what is the column? Result of analysis, inquest. To ascertain the actual cause of death during investigation, it learned that which fell down from the train due to heavy rush.
To ascertain the actual cause of death. Continue. He was traveling train. All down due to heavy rush.
Loss of passengers.
Rush of passengers. On searching one identity card.
Recovered.
Recovered.
So this is the report of inquest.
This
This is the result of inquest.
Yes. Yes. So, my lord, from this report, my lord, it is clear that he was a passenger of the train. He was not a trespasser in the train, in the line of the train, and he was knocked down. It is not possible for him to be knocked down by the train. Now, my lord, my lord, page number 48. Yes, we were. I have finished the judgments and not in view of the aforesaid discussion, the evidence of AW2 of the applicant and the was afterthought, and his name did not figure in the four corners of the claim application. Now, my lord, coming to the documentary evidence filed by the applicants, certificate reveals that Hon'ble did not died on this. In the instant case, the inquest report, which is being inquest report reveals that after proper investigation, it seems that as if the person fell down from the moving train. The witnesses also agreed. So this is
Yes.
the people who did the inquest report, who prepared the inquest report. They also discussed the matter with the people present over there, and they came to know from them that it is not possible for them to be present over there. It is evident from the inquest report that the investigating officer and also the witnesses were not taking it. Well, the learned tribunal is also not believing the investigating officer. For the reason I do not know. And also the witness were not definite, only presume that the victim fell down from this case and no eyewitness present at the place, and that's the oral evidence AW2 not considered. Now, my lord, preponderance of probability principle is applicable as it is a case of civil in nature and a social beneficial legislation. So whatever inference will be drawn, that will definitely go in favor of the victims, not against them. It cannot be used, such inferences cannot be used against the victim's family. Because there is every possibility the person was a bona fide passenger. He was holding a monthly ticket, my lord. He was holding an identity card. In the monthly ticket, my lord will find that in the monthly ticket, it is, my lord, exhibited. 61. It's 61 and 62. 61 and 62. 61. It is the monthly ticket. It was issued on 16th of October 2004 and valid till 15th of November 2008.
Yes.
And this monthly ticket, my lord, will find in the top portion. Mr. N. Devnath. His actual name is Noni Devnath. Here in short form, N. Devnath. Noni Gopal. Now, my lord, why this ticket does not bear the signature of this person, I can say, but it is, I am definite that this person, it was issued in favor of this Noni Gopal Devnath because it is a computer generated ticket. Now, my lord, kindly come to my lord, case number 62, my lord, it is the identity card. The last. This identity card. This identity
number
card. Identity card number is 065477. And my lord, this ticket also bears the same number 65477. 65477 is the number of the identity card. 65477 is the number which is printed in this ticket. So, my lord, this particular ticket was definitely.
What ticket?
Your post, huh?
My lord, ticket. This is not a ticket. This is the monthly ticket. Monthly ticket is valid only for this iCard. So this iCard number is
my lord, is 61 page number. The learned tribunal expressed its doubts on the basis of this thing. This is the monthly ticket, my lord. My lord, in monthly ticket, the thing is that, my lord, what is the
iCard valid for this month?
Without identity card, this monthly ticket has got no value. This identity card was issued in favor of Noni Devnath. It also bears his photo. And my lord, its number is 065477. Page number 62.
Yes. What is the number?
My lord, at the top.
No, in the number of the.
In the ticket, page number 61. Page number 61, my lord.
Yes. What is the number? Okay, ID number. Okay.
And that's my ID number 65477.
Yes. No, that issue was decided in favor of you.
So, my lord,
Yes.
tribunal.
That issue was decided in favor of you. So why you are arguing?
But while dismissing the case, my lord, it is also one point taken by them, is that the monthly ticket does not bear his signature and the identity card does not bear the stamp of the railway authority.
Very well.
So, my lord, I say my submission, my humble submission before your lordship is that he was a bona fide passenger and he has been able to prove that he was fell down from the running train and he was not a trespasser to the line and he was not knocked down by the train. And this eyewitness, this particular eyewitness, he was very much present over there and nothing has been brought out from the cross-examination of the eyewitness. Now, my lord, I will. So, on these two grounds, my lord, the case has been dismissed. So, he was a bona fide passenger, my lord, and the incident is also an untoward incident. Now, my lord, I want to place some judgments, my lord. Supreme Court judgment, my lord, Rina Devi. Union of India versus Rina Devi. Yes, my lord, there is civil appeal number 4945 of 2018. Union of India versus Rina Devi. Now, my lord, page number 11. First, I mean, my points. Page number 11, para 3. I could now reported. Reported, judge. Yes. Citation. What is the civil appeal number 4945?
Yes.
My lord, page number 11, para number 3. I cannot agree this proposition of law that the railway have on us to prove that the disease was not a bona fide passenger because no such negative onus is placed upon the railway either under the Railway Act or Railway or as per the judgment of the court. No doubt in the fact of the particular case, onus can easily discharge, such as in a case where disease may have died at a place where he could not have otherwise been unless he was traveling in a train. And in such circumstances, depending on such facts of particular case, it may not be necessary to prove the factum of the disease having a ticket, because ticket as per the type of incident of death can easily be lost in an incident. I at this stage take note of the judgment of a single judge of the court in case reported P.R. Singh versus Union of India 2007-8 AD Delhi 262, which holds that in the claimants upon whom the initial onus lies to prove case, I agree to this view that I am bound by this judgment and not by the ratio of Gilabmadis. Same was taken by single judge for Andhra Pradesh after referring the provision of the Evidence Act as follows. The initial burden of application never shifts unless the respondent admits the assertion made of the applicant. Such evidence is lacking except the oral assertion of AW1. No evidence is forthcoming on behalf of the applicant. The court may presume that the evidence which could be not produced, would if produced, be unfavorable to the person who is produced. The best evidence rule which governs the production of evidence in court requires that the best evidence of which the case in its nature is susceptible should always be produced. Section 114G of the Indian Evidence Act actually enables that the court to draw an adverse presumption against the person who can make available to the court, but obstructs the availability of such evidence and claims tribunal upon considering the materials of record rightly application, and there is no ground in the application. What is the congruence of circumstances appearing in the case, it was held that there is no evidence that the deceased has purchased the ticket. The given situation of this case, that it's referred that it was not a case of unqualified, but the case was run over. Is observed. The aforesaid report also revealed that the body of the deceased had been cut into 2 pieces and was lying next to the railway track. The report further indicates that the intestine of the deceased had come out of the body. The above fetal person revealed that the body was cut into pieces from the stomach. This can be inferred from the facts and expression of the inquest report that the intestine of the deceased had come out of the body. It is not possible for such an accident to take its place while boarding train. Our case is not such. In addition to that, in addition to the factual position emerging out of the perusal of paragraph 7 and 8 extracted here above, the report also reveals that besides a pocket diary having been found from the person of the deceased, few telephone numbers were also found, but importantly, the deceased was not in possession of the other article. This further clear the position adopted by the railway authorities, namely that the deceased Gafur Sahib was not in possession of a ticket for boarding the train at the.
This is the case of the Rina Devi. Yes, this is the
not
case of the Rina Devi.
not our. Rina Devi.
So what is your view here?
We thus, Para 8, my lord, page number 12. We thus hold that mere presence of a body on the railway premises will not be conclusive to hold that the injured or deceased was a bona fide passenger with the claim of compensation could be maintained. However, mere absence of ticket with such injured or deceased will not negative the claim that he was a bona fide passenger.
Now, in this case, you have the ticket.
Yes, my lord. Yes.
So in this case,
We have the ticket. We have the ticket. There is nothing to disbelieve. Whether the incident, my lord, the learned tribunal is there to find out the actual thing. What happened? Whether this person was a bona fide passenger or not, and whether he fell down. Whether this was an untoward incident. And if these two conditions are fulfilled, then the learned tribunal is bound to pass the award. Not to dismiss the case.
so what is your principle
So,
here?
my lord, initial burden will come to the claimant with discharge while findings of the affidavit will then shift on the and the burden will then shift on the railways, and this issue can be decided on the facts shown by the attending circumstance. This will have to be dealt with from the case to case on the basis of the legal position of this regard will stand explained according to the rate of agency. So, my lord, here we have been here we have been able to prove, we have properly proved that I was a bona fide passenger and I was traveling by the train. I was holding ticket. In this case, in Rina Devi case, there was no ticket. No ticket was found. Even then, the honorable court told that he was a passenger because there was a diary, etc. Now, my lord, in our case, my lord, I have been able to prove that I was a bona fide passenger. Whether there is any evidence, whether the police has made any fault, whether the police has not recorded anything, that is not my fault. That is not a thing we look after by us. So, my lord, we have been able to prove, my lord, that the deceased was a bona fide passenger, he fell down from the train, and he is entitled to get compensation. And there is another judgment.
Today we don't have the time.
Right.
So when can we hear?
Conclusion.
No conclusion, not judgment. This honorable court has got several judgments on this point.
I know. So what can
As well, lord.
next week? Usually in the parted matter come on top. Okay. So you give me the date. 18, 19. It would appear on top at 11.
And I have also filed an argument, my lord. I will also place that. 90.
You come on 19th. Okay.
90.
On top
In the morning.
in the morning. Please take down.
Every day, the morning.
Argument on behalf of the appeal and heard part. Let the matter be fixed on 19th of September. As a parted matter on top.
20. Well, 20 possible, my lord, will not be.
Whether 20.
And second matter was also, it is also similar to this.
similar কেন?
Let we conclude one thereafter.
সব similar ঢুকিয়ে দিলে হবে?
Second matter will appear tomorrow.
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 Yes,
Tomorrow.
it will appear on tomorrow as per list. Okay, thank you.
Much obliged.